All right, good afternoon, everyone. Let's call these two cases actually, Fremont County cases CR 22-2755, State of Vallow versus Vallow-Daybell, and Fremont County case CR 22-2838, State versus Vallow. Representing Mr. Daybell is Mr. Pryor. Mr. Haynes represents Ms. Vallow. Mr. Troy Evans on behalf of the prosecutor. Counsel, I would note that the defendants are not appearing today. I asked this before, but I'll do so again. Mr. Pryor, first, is it your client's intention to waive her right to an appearance at this, I'm sorry, his intention to waive his right to an appearance at this hearing today?
It is his intention, Your Honor, yes.
Okay, and Mr. Means, have you also discussed that with your client, and is it her intention to waive her right to appear for today's hearing?
It is, Your Honor. Thank you.
All right, thank you. We are conducting this hearing by Zoom, as we did before. We are recording it on the Zoom software. We also have our court reporter here today. We're also using the FTR recording system out of Fremont County, and the parties are appearing by Zoom. In addition, the hearing's being live streamed on the court's YouTube channel to allow access for the media and the public to this hearing today. This is a continuation of the hearing we had on January 6th, whereby the defendants have both filed motions to disqualify the prosecuting attorney. We took evidence at that time, and I allowed additional time for preparation and closing arguments. In the interim, counsel, I just want to discuss procedurally where we are. I received today a motion entitled a motion for testimony of Summer Shiplet. That's been filed by the state. It was filed this morning. I also would indicate I did receive additional briefing from the parties, and quite frankly, I just received those on very short notice here, and I'm probably going to need to take a bit of a recess to review through those written submissions prior to hearing the closing arguments. But I think we should first go through the issue of the state's motion. There was a request in the motion for an expedited hearing on that. I'll ask you, Mr. Pryor, did you receive a copy of that motion?
I did not. And Judge, in addition, I filed an objection to Ms. Gee's affidavit with the court this morning because I received the state's brief this morning, late this morning, as well as their alleged, or not alleged, excuse me, the affidavit of Ms. Gee indicating some representations of what Summer Shiplet said.
Okay, and that just, Mr. Pryor, that does relate to the motion. So are you indicating you've not received, this was filed at 9:17 a.m. It's entitled Motion for Testimony of Summer Shiplet. Have you seen that?
I have not.
Have you seen the motion, Mr. Means?
I have not seen the motion as of yet, Your Honor.
Okay, well, I'm going to go ahead and take a recess at this point. Let's go off the record. I just want to discuss procedurally where we are with counsel on these late filings, make sure everyone's had an adequate opportunity to review the filings that have all been filed today, including the court. And it is still my intention to go through with these hearings today and hopefully be able to get through everything and bring this matter to a conclusion today. But we do need to allow adequate time for that. So at this point, I'm going to call a recess to the hearing. I would ask that Madam Clerk arrange for a breakout room for the state and both defense attorneys and me. I'll have actually Ms. Gibson, the court reporter, also there in the breakout room. And I just want to discuss the logistics of getting these motions cross-submitted so all parties are aware of what's been late filed in the case. So that we'll take a recess at this time and wait for the breakout room to be available.
Thank you, Your Honor.
Darlene, can you hear me?
Yes, dear.
We're going to take a break for about 15 minutes for the attorneys to review all the documents that have been filed. Judge wanted me to let you know.
Okay, thank you.
Let's see, do we have Mr. Means, or is he still on break here for a moment?
Your Honor, I'm here. I'm sorry. Let me start my video.
Okay,
Let's see. Actually, Your Honor, it's saying I'm unable to start the video. I think I'm going to log out and try to re-log back in if that's okay.
that's fine.
Can you hear me, Your Honor?
I can, Mr. Means, can see you as well. Okay, we'll be back on the record then. Cases CR 2220-755 and 2220-838, State versus Chad Daybell and State versus Lori Vallow. We took a recess for the parties to review and receive these additional pleadings that have been filed in the case. I believe the parties have all had an opportunity to now review the pleadings. Mr. Means, did you receive a copy of the state's motion for testimony of Summer Shiflett?
I did, Your Honor.
And Mr. Pryor, did you receive that as well? You're on mute, Mr. Pryor.
I apologize, Judge. I did receive all of the documents, Your Honor. Thank you.
Okay, thanks. I appreciate you taking a moment for the housekeeping issues. Understanding we've had a lot of things filed here in a compressed time frame. And at this point then, I do want to take that motion up. It was requested to be done on an expedited basis, and as I understand, it may have a relation to the hearing we're determining today, so I think it's appropriate to hear that first. I would note that in addition to the motion, there was an affidavit of Mindy Gee and then a supplemental affidavit of Mindy Gee, which I believe counsel has seen as well. There was also an objection to the affidavits filed by Mr. Pryor on behalf of Mr. Daybell, asserting that they contain hearsay. So Mr. Evans, if you'd like to present argument on your motion for testimony of Summer Shiflett, I'll hear that at this time.
Your Honor, thank you. And it's just argument. Your Honor, as the court, I know the courts probably haven't gotten around to look at our brief, but motions to disqualify are viewed with caution. And when it's not dealing with current or former clients, there's heightened scrutiny that needs to be applied. And I've cited the case for the court on that. Witnesses are the most important aspect of our cases, and that's because they perform the sacred duty of assisting the court to discover what the truth is, and frankly, to assist all of us. This is why before they even speak in court, they need to affirm under oath that they're going to tell the truth. Where we've been the last few days, Your Honor, the defense wants the extreme remedy to remove Mr. Wood from this case. They claim he's been coercive, influence, coached, and this all has to deal with Summer Shiflett and his meeting with her on October 1st of 2020.
Your Honor, if I may, I apologize. I think it has to be said that we're arguing the motion for the testimony of Summer Shiflett. They have cited one rule in their motion, and we are well beyond that one rule. It attempts that they're trying to backdoor in additional arguments for this motion. And having failed to cite this, I don't think that's proper before the court.
I concur with Mr. Means, Your Honor.
Okay, let me address that, counsel. We are obviously still going to have closing arguments on the motions to disqualify the prosecuting attorney. We've got a narrow issue before us on what's styled as a motion for testimony of Summer Shiflett. And in reviewing the motion, Mr. Evans, I will just read directly from it that you've indicated that the motion is made pursuant to Rule 4.2 of the Idaho Rules of Professional Conduct, and you're requesting that this court contact and hear testimony of Summer Shiflett. So I'd just like you to confine your arguments to the narrow issue of whether or not this court should contact and hear testimony of Summer Shiflett, and if so, when would you be requesting that that take place?
Your Honor, very good, thank you. Once Ms. Shiflett, so the history on that, after our hearing a couple of days ago, everyone knows Ms. Shiflett called the prosecutor's office.
Judge, I'm going to object at this point. I've filed an objection to Summer Shiflett's affidavit being considered in this particular case. If Mr. Evans would like to cite the case and the case law and the statute that grants the court authority to hear Ms. Shiflett, by all means go ahead. But if he's going to regurgitate things that have happened that are clearly inadmissible, we're going to have a problem. And I'm going to strongly oppose this going down this path at this point.
I understand, Mr. Pryor, and I think to correct you, it was the affidavits, not of Summer Shiflett. She hasn't submitted any affidavits.
Mindy Gee, Judge.
Mindy Gee, yeah. And there was a objection made based on hearsay, and I am going to consider that objection and hear and rule on that before we get into what Ms. Gee has to say in her affidavits or what Ms. Shiflett is alleged to have said to Ms. Gee. So I would like to hear, Mr. Evans, there's an objection to those affidavits requesting the court not consider them based on hearsay. And what is your response to the hearsay objection?
Your Honor, it doesn't go to the truth of the matter asserted. Also, she just wants to talk to the court. That's the bottom line.
Who does?
Ms. Shiflett.
Your Honor, I've got to object to the representation of what Mrs. Shiflett has allegedly said to this Mindy Gee, now attempting to come in through Mr. Evans. I mean, we now have multiple levels of hearsay here. And quite honestly, this motion it was identified 10 to 14 days ago. Forgive me, I don't remember the exact date. Mr. Evans, in his own argument, has had plenty of opportunity to attempt to contact Summer Shiflett or even opposing or Mr. Garrett Smith. And it doesn't appear that there were any efforts to do that prior to the hearing 2 days ago. And so again, if we're going to make statements regarding what somebody said to somebody, again, additional problems.
All right.
And Judge, if I could just add that even if Mr. Evans wants to suggest he couldn't go to get a hold of Ms. Shiflett because of Mr. Smith, we have a subpoena process. And I would assume that 2 lawyers from the state would understand that they have every right with 2 weeks notice to subpoena any witnesses that they feel would help their case. Instead, what they did, Judge, is they provided no evidence whatsoever. And at the conclusion are attempting to do this backdoor tactic, the same kind of backdoor tactic that we had one of the other expert witnesses talk about.
All right.
Bringing, so
we're beyond the scope of a hearsay objection as well. So I want everybody to keep in the confined scope of a hearsay objection. Mr. Evans, you indicated it's not being offered for the truth asserted, but you are turning around and then saying, well, here's what someone told Mindy Gee. So I just need to know, do you have a specific exception to the hearsay rule which would allow consideration of these affidavits?
Your Honor, thank you. We're just looking at Rule 803, I think under 1, the present sense impression, so a statement describing or explaining an event or condition made immediately after perceived it, and then as well as the catch-all, the other exceptions, looking at the trustworthiness of it, the factual basis of it, and then the probative point of it. So that's under Idaho Rules of Evidence 803.
All right, I'll allow a response to the argument that there's an exception that applies here under 803.1 and the catch-all. Mr. Means first, and then Mr. Pryor. And counsel, please, again, we're only on an issue here of, do these affidavits contain hearsay? You'll have plenty of time for other argument on the other bigger issues here, but keep it confined to that. Mr. Means, what's your response to the state's indication that there's an exception that would apply?
Thank you, Your Honor. And looking at these affidavits, there's not a lot of difference between the two of them. I think we do have a problem where we have hearsay and then we have double hearsay. And I think the analysis would have to be provided at both levels. I think the present sense impression does not apply, to be quite frank. And trustworthy, I think we have an issue because I don't even think these could be characterized as midnight affidavits, considering this is after the fact of the hearing. This is more of the morning after. So I think trustworthiness is an issue as the prosecution attempts to be coming kind of in a backdoor manner to address what should have been addressed at the hearing 2 days ago.
All right, thank you, Mr. Means. Your response, Mr. Pryor.
Judge, I'll start with the last one, which would be the catch-all, which is usually a tactic used in court to try to get something in when there's no other reasonable reason to get it in. So that's not applicable in this particular case. Trustworthy is not applicable in this case. That's for the court to gauge whether or not a document, and really quite honestly goes to more authentication. The present sense impression, Judge, you know, that's taught in first-year law school. And that's an impression that someone gets upon observing a startling event. And quite honestly, Judge, there's been 14 days for Ms. Shiflett to do this. To suggest that after 14 days we've had a startling event that warrants her to come forward with something is ludicrous. So quite honestly, I can't even by the minimum stretch of my mind imagine any situation where present sense impression would even remotely apply to this. They are grasping. And now I know why they're grasping, because it took a significant amount of time for them to come up with a response while we patiently waited for them to address the hearsay issue. This is hearsay. It doesn't come in. And Judge, again, I guess yesterday I was temperate and I was upset, and I'm still that way. And I want to apologize to the court for that, because I don't mean to be, but this is a very disturbing situation, and to suggest that it's present sense impression is just completely ridiculous. And again, I apologize to the court for my temperament.
All right. I've considered the objection filed. There's an affidavit of Mindy Gee. There's also a supplemental affidavit of Mindy Gee. There's been an objection made that portions of those affidavits contain hearsay. I've reviewed it. The statements of Mindy Gee about what she did in terms of taking a phone call are not hearsay. That's her own testimony in the affidavit that's sworn. However, these statements as to what Summer Shiflett told Mindy Gee, that Mindy Gee is now telling the court, is clearly hearsay. And so the court will not consider and will strike those portions of both affidavits that pertain to any statements made by anything that Summer Shiflett did say. So that'll be my ruling on those affidavits. All right, with that in mind then, Mr. Evans, would you continue with argument in support of your motion to allow the testimony of Summer Shiflett?
Your Honor, yes, we've found no rule for the court to disallow further evidence in a hearing. This is not a trial. This is just a hearing. There's nothing that says the court has to follow timeframes, especially if the result is a manifest injustice. We believe that the record that the court's trying to rely on is going to be entirely empty of the facts that go to the heart of the issue. And the heart of the issue for the court is, did Mr. Wood's communication with Ms. Shiflett, were those influence, and that led to her changing her testimony to law enforcement. So we believe that her testimony is absolutely crucial. She is the person that we're talking with in all of these matters. and she wants to testify, and we ask the court to allow her to do so.
All right, thank you, Mr. Evans. Response to the motion, if there's an objection, Mr. Means.
Thank you, Your Honor. Again, I think the argument is well off of what the motion that is before the court. The only, if we could even call it a rule that applies, is they cited Idaho Rule Professional Conduct 4.2 entitled Communication with Persons Represented by Counsel. There is nothing expressed or implied in that rule that allows the court to entertain this motion. There's no attempt to cite any kind of criminal rule or even an implied civil rule that might be duplicated in the criminal rules here. So we're limited again to the argument of, based on the rule 4.2, communication with persons represented by counsel should justify them in bringing this morning after motion. We've been down this road before, Your Honor, when we had a motion for a judicial protective order in a rule in the Idaho Rules of Professional Conduct that did not apply. It's the same attempt by counsel here to attempt to do the same thing, which is inapplicable in their request and the remedy in which they're seeking.
All right, thank you, Mr. Means. Your response, if any, Mr. Pryor, please.
Judge, there was a hearing set. I believe Mr. Means disclosed his witnesses and his exhibits. I disclosed my witnesses and my exhibits. Mr. Wood, at the time, through his counsel, chose yesterday at a trial not to present any evidence. He made some brief, very brief cross-examination of some of the witnesses, but nothing else. Now, at this point, at the last hour before we were to make closing argument, this is an attempt to get information in through the back door. And that backdoor process is going to be violative of my client's right to a fair opportunity to present his argument here. Because, Judge, if you allow Summer Shiflett in, I am going to be compelled to ask the court to continue ruling on this motion so that I can bring Mr. Smith back, put him back under oath, and offer rebuttal testimony for Mr. Smith to counter whatever Ms. Shiflett says or to concur with whatever Ms. Shiflett says. And I don't know what Ms. Shiflett says. I haven't heard from Mr. Smith whether Ms. Shiflett even has legal counsel. And if she has legal counsel, Judge, Mr. Smith needs to be present for that examination. And quite honestly, if they're going to be allowed to reopen something that this court closed, and they have cited no rule that allows them to reopen this other than a professional conduct rule, which is totally inapplicable, they shouldn't be allowed to do this. Because if that's where they're going, rebuttal is going to include Mr. Smith again. It's going to include an examination by Dr. Davidson again. It's going to include an examination by Dr. Newton and potentially one other witness that I'm going to call to address that. And quite honestly, this is just an opportunity to somehow backdoor some information in that doesn't go to the root of what the problem is. I think counsel for Mr. Wood misunderstands. The due process argument is only a very small portion of this argument. The reality of the argument is this, Judge. Mr. Wood engaged in conduct that defense counsels both found objectionable. It's not the impact on the witness that the conduct, that's the question here. The question is whether his conduct itself was egregious enough to have him removed as the prosecutor. It has nothing to do on the influence other than the small portion of due process that'll be addressed later in another motion. The question here is whether Mr. Wood's conduct was egregious enough that it warrants some sort of action by this court. And the example is, Judge, this. Obviously, all of counsel agree that case law on this is very limited and there's not a lot of precedent. But if a prosecutor were to talk to a witness outside of the courtroom and say, oh, by the way, before that witness took the stand, by the way, the defense attorney's a liar and all of these other things that have been alleged well, not alleged, they're on the tape. And then that witness was permitted to take the stand. It would not be the impact on the witness that the court would be evaluating. It would be, what did you say to that witness that potentially influenced you? So that's what the consideration here, Judge, is not what the impact was on Ms. Shiflett. It's what conduct was engaged in that caused the problem that he should not have gone down that road in terms of the way Mr. Wood presented himself and acted for 20 minutes on a tape. So quite honestly, Ms. Shiflett's testimony is really irrelevant to this. It's the conduct of Mr. Wood that's in question here. And I vehemently am opposed to allowing Ms. Shiflett to testify at this point.
All right, thank you for the response, Mr. Pryor. Mr. Evans, rebuttal argument.
Your Honor, just one clarification. If you look on paragraph 10, let me just be clear what the state's wanting to do. So moves this court to allow contact with Ms. Shiflett. The court knows bar counsel was called with this. So the prosecutor's office contact with Ms. Shiflett and or allow her to testify in the court. So rule 4.2, if you look at the very bottom, that is the state asking to contact her. And so how do we do that when they have been represented by an attorney? You need to get permission from the lawyer, if she still has one, or authorized to do so by the court. So that was done with bar counsel, and that's what the motion is. So it's the state to communicate with her as well as her to communicate with the court. Thank you.
All right, thank you, Mr. Evans.
Your Honor, may I respond to that rebuttal? Because there were some new arguments made there.
Keep it brief, Mr. Means.
I will, Your Honor. When we go through the affidavits of Mindy Gee, given the rulings of this court, the only thing that's admitted that's not stricken as hearsay are paragraphs 1, 2, and 3 of both of the affidavits. Paragraph 4 on the original affidavit would be limited to, on January 7, 2021 at approximately 2:53, I took a phone call from a female individual. And then the portion after that would be hearsay. Then it says, I stated that he was not available and asked if I could take a message. The rest would be hearsay. Concluding on paragraph 4, the only portion that's not hearsay then says, and I told her I would relay the message. The phone call then ended. The same thing applies to the supplemental affidavit. 1, 2, and 3 should be admitted pursuant to this court ruling. And paragraph 4 is limited to, on January 8, 2021 at approximately 9:30, I answered a phone call from a female individual who, and then the rest is stricken as hearsay. So we don't have affidavits supporting this motion as a result of the court's ruling. There's also additional hearsay from alleged statements of Ms. Shiflett in their motion. In addition, if we look at rule 4.2, and again, this is just brought up this morning, if you look at comment or paragraph number 6, what they're requesting is beyond what the rule cites. Again, there's no grounds to allow this cited in this rule. If they're asking for permission to speak with Summer Shiflett, I don't think any of us have an objection. The problem is they're attempting to extend the rule or imply what's not in there of give us permission to speak with her and have her testify. That's not part of the rule, Your Honor.
All right, thank you, Mr. Means.
Thank you.
Well, counsel, I've considered this motion in terms of where we are procedurally. Of course, we had a very lengthy hearing 2 days ago on the 6th. We took evidence and testimony during that hearing. We then concluded with the hearing and closed the submission of evidence. This is essentially a request to reopen the submission of evidence, and the request specifically to allow, as the motion reads, for the court to contact and hear the testimony of Summer Shiflett, and then in paragraph 10 to allow her to testify before this court. And that would be based on, again, Ms. Shiflett's request. It says, as Mr. Means pointed out, with the striking of the portions of the affidavits of Mindy Gee that contain hearsay, then the grounds for the motion don't qualify without those statements. And in addition, the motion is brought pursuant to the Idaho Rule of Professional Conduct 4.2, and the court's not aware of the Idaho Rules of Professional Conduct being a proper basis for bringing a motion. At this time, for purposes of the hearing today and our closing arguments, I am going to deny the motion to allow the testimony of Summer Shiflett. So the evidence submission is still closed, although we do have the arguments that have been submitted, which will be considered. So that'll be the court's ruling on the motion. This time then we'll proceed with our closing arguments. Counsel, as I mentioned, we went through and reserved today for these closings. I'd like to take those up at this time now, and I'll just let you know I'm intending to hear your oral arguments. I'm going to take a recess at some point and further review your submitted briefing in addition, but Mr. Pryor, it'd be my intention to have you begin with your closing, then have Mr. Means, and then I'll have the state respond in their closing as well, and then see if there's any rebuttal arguments. So, Mr. Pryor, are you ready to proceed with your closing argument?
I am, Your Honor, if I may.
Go ahead.
Judge, I think there's a misunderstanding by counsel for Mr. Wood. The basis for disqualifying a prosecutor is conduct. It's not the impact that it has on the witness, but rather its conduct. And what I spoke about, Judge, was this in the example I gave just a short time ago. The example is this, is that if you have a witness who's about to take the stand in a jury trial, and either party for that witness approaches them and makes disparaging remarks about defense counsel, makes disparaging remarks about the defendant, and I can't see in any situation where suggesting that someone's a wimpy person or looked like he was about to pee his pants are not disparaging remarks. I can't see where calling Mr. Means incompetent is not a disparaging remark to a material witness. And whether Ms. Shiflett testifies or not for the prosecution is irrelevant. Because if I choose to call her, she becomes relevant. If Mr. Means chooses to call her, she becomes relevant and material. And she's the sister of one of the defendants in this case, who was told, oh, by the way, you know, she won't talk to us, but this is what I'm going to do, and I'm going to charge her with murder. And it would sure be nice when she has competent counsel. Maybe we can get this thing closed up. I can't think of any more direct way that he's trying to circumvent Mr. Means' authority as counsel for Ms. Vallow. It's egregious. It is incredibly egregious. Now, Judge, the Idaho Rules of Professional Conduct have adopted the ABA model rules. And the ABA model rules, and Judge, that says it right in the preamble to the Idaho Rules of Professional Conduct. We have adopted the ABA rules from 1969. And under the ABA rules, ethical considerations, Rule 9.4, because the very essence of our legal system is to provide procedures by which matters can be presented in an impartial manner so that they may be decided solely upon the merits. Any statement or suggestion by a lawyer that he can or attempt to circumvent those procedures is detrimental to the legal system and tends to undermine the public confidence. Now that's from the ABA rules, Judge, which have been, for all practical purposes, adopted in our Idaho Rules of Professional Conduct.
Mr. Pryor, I do want to make a correction there, because the Idaho Rules of Professional Conduct are, as it states in the preamble, largely based on the ABA model rules with some Idaho variations.
That is correct.
I would ask that if I'm following along here, if you're citing to any specific rule of professional conduct, please cite to the Idaho rule, because they are largely the same, but if there's a difference, we need to rely on the Idaho precedent. So, and
I understand that, Judge, and what I'm trying to do is I'm trying to say, in the spirit of adopting the Idaho Rules of Professional Conduct, they considered the ABA rules, and it still goes to the same essence, Judge, which is this. Our Idaho Rules of Professional Conduct require that we do everything we can as lawyers to engage in an impartial system that does not allow undue influence from any party or their attorneys to jeopardize the opportunity for a defendant to have a fair and impartial trial. I cannot think of any situation that is more egregious than a prosecuting attorney who would go in and interview a witness and for 20 minutes not interview the witness, but rather offer a monologue of what his theory is in the case, disparage counsel, disparage the defendant, and manipulate. Now, I want to point out that the prosecutor in this case presented no evidence in rebuttal to counter Dr. Davidson, to counter Dr. Newton, and to counter Attorney Garrett Smith. They offered nothing. And to suggest this high scrutiny by Mr. Wood's attorney is completely inaccurate. The question is whether or not an attorney and a prosecutor who's required to live by a higher set of rules has engaged in conduct that jeopardizes Mr. Daybell and Ms. Vallow's right to a fair trial. Now, the purpose of Dr. Davidson, Judge, is this. I did not want to, and I can't speak for Mr. Means, but I didn't want to subject Summer Shiflett to all of these people out there watching this and put her on the spot. Dr. Davidson got on there and he testified that it's, without credulity, that there was not influence here. He's suggesting, listen, there's no way there wasn't influence here. And he specifically put a report that has been admitted and detailed every single line of where Mr. Means engaged in completely inappropriate conduct. Now, I read the brief from opposing counsel and they said, well, this isn't what was going on, but Mr. Wood's affidavit in the original objection to this, Mr. Wood specifically said in his statement, I did not coach, influence, or intimidate any of these witnesses. Well, I beg to differ, Judge. Dr. Davidson, in no uncertain terms, stated implicitly that these statements clearly were influential in a attempt to influence Ms. Shiflett, without a doubt. Dr. Newton, when we talked about the process here and what was transpired, what did he say at the conclusion of the hearing? Well, the reason we don't have these sort of things is because it's unusual for these matters to occur other than in front of a jury. But when they occur in front of a witness, it's a rare situation. And you want to believe a prosecuting attorney. You want to believe someone who is supposed to be righteous and uphold justice and do it the proper way. And the tendency with courts is to say, listen, unless you have some proof that the prosecutor has engaged in some conduct that is detrimental to the administration of justice, I think it's appropriate because his job generally is to uphold justice. But what did Dr. Newton, the expert on case law, the expert on authority, what did he say that was compelling? He said, he, meaning Mr. Wood, got caught. Now, getting caught is not the term you use unless either you're fishing or you're lying or you're cheating. And Mr. Woods is cheating, Mr. Wood is lying, and Mr. Wood is doing nothing but trying to influence, coach, intimidate a witness before that witness has had a chance to get in front of a trial. My concern is this, Judge. I don't have any other recordings other than Zuluma Pastenes. And I'll be going through that, and we may be revisiting some issues once I've had a chance to go through that in the final interview with Ms. Pastenes. But I don't have any other tape recordings. But what I do have is an interesting thing that occurred. And I know this court wasn't part and parcel of the preliminary hearing back in August of this year. But I had an opportunity during that preliminary hearing to talk with Ms. Gibbs while she was on the stand. And I was questioning her about what she knew, what the prosecutor had said to her. And after I asked her what the prosecutor had said to her, Judge, she immediately turned on the camera and looked directly in Mr. Means's eyes. And I said right after that, why were you looking at Mr. Means?
Your Honor, I'm going to object for hearsay.
This is argument, Judge. This is argument. This isn't the presentation of evidence.
I understand, but you're still referencing a specific comment someone made out of in a separate proceeding. I think that's hearsay.
Okay. Well, Judge, my concern is this, is that having to bring up the subject of whether Ms. Gibbs was looking at Mr. Wood when I said that, and the fact that I brought it up, and the fact is, Judge, I observed Ms. Gibbs look in the eyes of Mr. Wood when I'm questioning about what sort of conversations they had. That causes me great concern. And everybody in the world can look at it on YouTube and see that there was concern. So what assurance is the court going to be able to give me that these meet and greets that Mr. Wood has engaged in, these 20-minute monologues, have not occurred with every other witness in this case? Because if the court cannot give me assurance, you're going to require me to go to every witness with an investigator, interview them, and question them in detail about what Mr. Wood has talked to them about and whether this meet and greet tactic that is completely unprofessional, that is completely unethical, that is completely wrong was conducted on other witnesses in this case. And if that can't be questioned to a certainty and assured that there hasn't been influence with other witnesses, how am I going to be sure that there's going to be a fair trial for Mr. Daybell? Because you can't. And there is only one thing this court can do. We need to remove Mr. Wood, and then there'll be additional requests regarding the witnesses further down the line in terms to how we try to cure this atrocity. Judge, there are a number of problems that I have in terms of the Idaho Rules of Professional Conduct. And in terms of the Idaho Rules of Professional Conduct, Judge, we do have Rule 4.2. And Judge, it is misconduct if you violate any of the Idaho Rules of Professional Conduct. And at this point, under 4.2, you are not allowed to encourage or in any way try to contact someone who has legal counsel. I cannot see how Mr. Wood's statements leading Summer Shiflett through this process of, oh, it's going to be murder charges, and it would sure be nice if we could communicate with Miss Vallow about this. And as Dr. Davidson implied, it seemed to be, and Dr. Newton implied, it seemed to be a back way for Mr. Wood to try to get Ms. Vallow to speak. Now that's clearly a violation if you're trying, even secretly or indirectly, to try to communicate with a witness or with a defendant who has legal counsel. That is a big problem. In addition, he violated the preamble. He is not doing this. There is no way anyone can suggest that his comments did not influence or attempt to influence a witness in a case. That's not justice. 3.8, the prosecutor's obligations. He violated his obligation as a prosecutor to try to present an impartial hearing, and his heightened obligation to do everything that he could to be fair and afford the opportunity for a defendant to have a fair trial is a violation, another violation. And Judge, I can spend hours going through and point out a number of these. Now, obviously, I've been verbose, and I've been verbose in the past, and the court has been very patient with me. But if the court looks at the transcript of the proceedings by Dr. Davidson, if the court reviews Dr. Davidson's report, he makes an emphatic representation that this was influence. Now, Dr. Newton was not going to circumvent the court's authority to make that decision. Dr. Newton was not going to override the court's power and say, oh yeah, this is prosecutorial misconduct. He said that it was up to the court to make that decision. It's up to the court to decide whether this is enough for there to be a disqualification of Mr. Wood. But what he did say, which was interesting to me, Judge, is this. He said, you know, Mr. Wood's behavior was a learning moment, and he meant for his future students at law school. It is a learning moment on what not to do. On what not to do. That would suggest to me that it's a clear ethics violation. What else would suggest to me from Dr. Newton that it was a clear ethics violation is that he would get caught and that he got caught. And again, as I stated before, when someone says you got caught, either you're fishing or you're breaking the law or you're a cheater or you're a liar. I'll pick which adjective because I don't think Mr. Wood was fishing. Now, Garrett Smith in one of his closing arguments at the end or his testimony stated, I can't see any possibility other than that it was influencing or attempting to influence Summer Shiflett, and there is no reason for why Mr. Wood did this. Judge, the totality of the circumstances are this. We have one of the biggest trials in the state of Idaho, and people are watching this with attention that I can't even fathom. We are all under the gun and we are all being watched very carefully. And any first-year attorney who's going through law school is entrusted by ethics and taught about ethics, that these are the things you do not do. And Mr. Wood has been practicing for a while. He has told me before that I did plenty of defense work. I'm a prosecutor now. And Judge, for the record, he also told me on 2 separate occasions.
Your Honor, objection for hearsay.
Sustained.
Judge, I can't think of a reason why Mr. Wood would need to go out and interview Summer Shiflett. Mr. Wood took it upon himself to go out to Arizona to interview a witness. He knew before he was leaving that he was going to engage in this meet and greet and do this. Because if he didn't know that he was doing it, then he doesn't understand the rules of ethics. He can't say, oh, I didn't know what I was doing. He knew darn well what he was doing. And the only problem and the only complaint is this, Judge. He got caught. In the infamous words of Dr. Newton, he got caught. And to suggest by distracting, saying, well, Ms. Shiflett will say something else. Or, Judge, the impact on the witness. That's not the standard. It's the conduct. The standard is, was your conduct so bad that it had an impact on the trial in this case? I can't think of a more egregious situation other than a prosecuting attorney in one of the most high-profile cases in the state of Idaho, and I could argue, Judge, in the United States. I don't know how many people are watching me right now or watching us right now, but I would imagine it's significant. And this prosecutor, with full knowledge and at the expense of Fremont County, chose to fly out to interview a witness and suggesting that it was going to be a meet and greet, and then spends 20 minutes of a narrative doing everything he can to influence this witness to testify a certain way. And it's not whether the witness was influenced. It's the fact that he did it. And who else did he do it to? What other witnesses in this case did he do? Because we'll never know. We will never know the extent of what this prosecutor has committed in this particular case. And I can't think of any better reason to disqualify him than the fact that we don't know what else he has done. And quite honestly, Judge, anything he says about what he has or has not done, I have very little faith in anything Mr. Wood will say. And at this point, I will defer to counsel.
All right, thank you, Mr. Pryor. Mr. Means, your final argument.
Thank you, Your Honor, and I obviously concur with Mr. Pryor on his points made. Does the court want me to go ahead and attempt to argue some of the points made by the state's brief that was filed this morning as well in the closing, or do you want to save that for rebuttal, Your Honor?
I'll leave that up to you, Mr. Means. If you want to address the points in their brief, at some point we'll get to that. You can determine if you want to do that in rebuttal. I'll allow rebuttal, or if you'd like to do that now in your closing, you can.
Thank you. I just, in trying to organize my thoughts and present it in a more efficient manner, I'll try to go through it rather quickly. I filed this morning a post-motion hearing brief in support of the motion to disqualify. Overall, the motion doesn't introduce anything that wasn't presented at the trial in this matter, but to assist the court in the finding that Mr. Wood should be disqualified from this action. It's a summary of the pleadings and the filings which have been filed in here with some dates, and then some reference and summaries to each of the 3 witnesses that were that had an opportunity to testify before this court. I'll go ahead and I'm going to object to any and all potential arguments by the prosecution in this case that were not expressly brought up at the hearing, either through lack of evidence or lack of questionings or limited to their cross-examination questions. I think anything else would be in violation of the spirit of the law of closing the evidence in this matter. And we can take that up obviously as we go along. In summary, Your Honor, when you look at the recording and you read the transcript, I think the initial impression is red flags are raised, eyebrows are raised. When you listen to it again, I think it becomes quite a bit more disgusting when you hear the tone and the phrases and the speed of the language and the words used. When we look at here in a summary, you have Mr. Wood admitting on this recording that he was in Hawaii at the time that Mrs. Vallow-Daybell, was arrested. He was in Arizona at the time that these statements from these witnesses were taken. I still have yet to try to figure out why he's present at any of this. As I listen to this recording over and over, I think the biggest question is why? Why are we here? Now we have spent substantial amount of time with the court, tens of thousands of dollars, many hours in the court's time and the attorney's time, and addressing an issue that should have never been an issue to begin with. And in response, the only objection or evidence that the state has put forward is their initial objection and an affidavit of Rob Wood. And then we have very limited cross-examination questions at the actual hearing. When we look at, in addition, when this tape was discovered, I served on December 17th, and this is part of the record that is readily available for everyone, a specific set of discovery requests to the prosecutor's office asking what contact, in summary, what contact this prosecutor's had with all of these witnesses, and I listed some specific witnesses. Discovery responses were due to that specific request by January 2nd. That's the 14-day limitation according to the rule, Idaho Criminal Rule 16. It's expressly set out there.
I'm going to object. I just don't remember any discovery things being brought up in the hearing.
Well,
Your Honor,
there's a separate issue out there, Mr. Means. I think, correct me if I'm wrong, did you file a motion to compel?
I did file because it's now time to file that motion to compel. But why this is, sorry, Your Honor, I don't mean to.
I'm just going to say that's not being heard today. If there's a need for hearing a motion to compel and you still don't have responses and think that needs a hearing,
sure,
we'll get that scheduled and take that up at another time. So go ahead and move on.
Your Honor, and I understand that my intent for arguing this is we were limited in presenting the evidence before the court of potential other violations of inappropriate contact with the witness, and we attempted through the proper means of discovery to get this evidence from the prosecution, and they failed to respond. There was no request for an extension of time. There was no denial. There was no objection to the discovery. They failed to respond.
Your Honor, I'm just going to object to that again for the same reason.
All right, I'll sustain that objection. We're not doing the motion to compel right now.
Sure. Thank you, Your Honor. When we do a summary of why Mr. Wood should be disqualified here, we have four main exhibits for the court to consider. First one is the transcript of the recording, the actual recording of the monologue, and then the expert reports 3 and 4 of Dr. Davison and Dr. Newton. There were 3 witnesses that testified. Prosecution had ample opportunity to call contrary witnesses or cross-examination, extended cross-examination, and they chose not to. We had attorney Garrett Smith of 27 years. We had Dr. James Davison and Dr. Newton. All of these witnesses, or excuse me, let me go through Mr. Garrett or Mr. Smith first. He testified right up front that he had an opportunity to listen to the recording. In fact, I believe the recording was played at the hearing with him on the Zoom stand, I think we would say. And he testified that it was an accurate copy, an accurate depiction of the conversation between Mr. Wood and Ms. Shiflett, that it was unaltered and it was a true copy. He then goes on and states that the affidavit filed by Mr. Wood in this case is false according to his opinion and recollection of events, specifically affidavit paragraphs 4, 6, and 7. He also has the opinion that the only intent of, the opinion that the only reason to really engage in this type of behavior was to unnecessarily and unduly influence Mrs. Shiflett. That Mr. Wood, and I think this adds to the fact that Mr. Wood knew Shiflett was a member of the Church of Jesus Christ of Latter-day Saints, or LDS, and that he knew she had strong convictions and feelings regarding that religion. He also knew that she has a strong emotional connection with her sister, Lori.
Your Honor, we object. These are facts, not in evidence. We have no idea what Mr. Wood knew or didn't know.
Your Honor, the objection should have come, if that was going to be, at the hearing. This is summarizing his testimony for the court that was not objected at the time that this was presented.
And I'll overrule the objection because it is some summation of this testimony. So you may proceed, Mr. Means.
Thank you, Your Honor. No, it's important to context this entire conversation that Mr. Wood is having with Ms. Shiflett, having this knowledge here. I think it's an important factor for the court to consider when it's analyzing coercion and manipulation and intimidation and these type of things that come up at a later time. In Mr. Smith's words, he said his 27 years of practice, he's never seen a prosecutor engaged in this type of behavior, that it appeared to be targeted at coaching and influencing the witness, and it appeared to come across as a win at all cost type behavior. This is obviously an issue for the court to consider. Dr. Davison, again, testifies in reviewing the recording, the transcript, and looking at the affidavit of Mr. Wood, that the affidavit again filed by Mr. Wood, paragraph 4 and paragraph 7 are false according to his expert opinion. He also testified that Mrs. Shiflett is a vulnerable witness, and the knowledge that Garrett Smith provided to the court of Mr. Wood is important in determining that, yes, there should have been gloves on the hand when handling Ms. Shiflett in this situation. He goes on to say, Dr. Davison, that the monologue is troubling, that appears to be no apparent effect to seek impartial testimony from the witness, numerous efforts to influence and exploit and shape the witness narrative. He also goes on to say that the prosecution pours his theory of the case into this witness prior to the testimony of the witness, that there are derogatory remarks regarding defendant Chad Daybell and myself. And when you actually look at the recording, he's also in certain ways derogatory toward Mr. Pryor and my client when you look at his opinions that are being expressed. He also attempts to bring in LDS doctrine as an authoritative speaker on behalf of that doctrine. He also attempts to assimilate or build a commonality with Mrs. Shiflett based on mutual beliefs in the LDS Church, which obviously is completely inappropriate. He also goes on to say that Mr. Wood engaged in coaching, testifying, and had an effort to unduly influence the witness. He attempted to shut down the witness. He attempted to control the narrative, and there's little interest in what the witness's information that will be provided. He's attempting to increase his credibility through derogatory comments and mutual association with religious beliefs. He attempts to, there's a prima facie influence of the witness. He halted any disagreement by Ms. Shiflett. And again, summary, he engaged in derogatory remarks as if we are in third grade in an attempt to, according to Dr. Davison, affect this witness. He summarizes by saying that there are minimal attempts from the state here to actually get the witness statement rather than to say his own. Now, when we look at the prosecution had an opportunity to present cross-examination and additional witnesses, there was minimal at best. I think they went into some questioning regarding page 5 of the transcript, lines 8 through 11, I believe, and that was the only substantive questioning there. And Dr. Davison handled that with his, my opinion remains the same. The words are there. His report remains uncontested. Dr. Newton, professor, University of Law, published author, also came in and said, and I admire his opinion for not trying to come across as to tell the court what to do, but to give you the information and allow the court to make the decision. He says he was, even though retained by my office, that his testimony was given freely, voluntarily, and without any coercion by any party. His summary, and I think this is important, he identifies and properly identifies Mr. Wood as acting in a quasi-judicial figure, a higher standard of law. Not only do we have the Idaho rules of professional conduct that apply to all of us, but there's a higher standard of law for Mr. Wood. If I could put it in summary, the ledge for a typical attorney to fall off is a little further away than it is for the prosecutor. He goes on to say that Mr. Wood presents his case to the witness as if conclusive and sound. He goes on to provide information that is not readily known. He said, Mr. Wood is providing unknown information to the witness could be found to have unfairly and improperly influenced the witness to alter her testimony. Now, again, this is all caged or described in an attempt to allow the court to come to the conclusion. He also goes on to incentivize, according to Dr. Newton, the testimony of Summer to coincide with the state. This is, as Dr. Newton cites, potentially unethical. It's also potentially criminal. He goes on to say that the prosecution, without question, poured his versions of facts into this witnesses. He calls this horse shedding, wood shedding, and coaching. And he also goes on the site and says, this is widely condemned. This is not getting to the line. This is a no-no. He then had, by Dr. Newton, put Shiflett in a compromised position. And just thinking of how this is going to affect ultimately this case is mind-boggling at this point in time. He says his behavior bordered on intimidation, that he attempted to possibly circumvent the attorney-client privilege between myself and my client. He goes on to say that the use of religious beliefs, affiliation, and authority is an improper use. The derogatory remarks are improper, and that these remarks and his monologue serve the purpose of predisposing a witness against the defense. This not only he said this violated the spirit, if not the letter of the law of the Idaho Rules of Professional Conduct and potentially the Idaho laws regarding witness tampering. He also goes on to say that there are coercive aspects. This is all of the things which are uncontroverted, unchallenged by the prosecution. I think the question before the court is, what standard do I review this? And it's my argument that this is a standard of abuse of discretion, that the court has to look at this issue and determine, have there been enough violations here, just in those cited by those experts, to justify removal, to ensure the integrity of this process. The Idaho rules, as the court has mentioned, asks us to cite specific rules. I've read these rules. I've read the comments. I see a plethora of issues here. We got a violation of the preamble. We got a violation of Rule 3.4 A, B, C, F. We got a violation of 3.5 A and D, Rule 3.7, Rule 3.8 A, D, F, G, 1, Rule 4.1, 4.2, 4.4, A1, Rule 8.2A, 8.4, A through E. These are major issues, Your Honor. And again, the question has to ask, why are we even here to begin with? These, in addition, this recording is going to have application to this entire process. Your Honor, in looking at their brief quickly, I have in my notes here at the beginning, it's a 13-page red herring. They assert contradictory positions. They imply that the prosecutor may have acted in a matter of error, but that's not enough to disqualify him. It cites various standards of law that they say apply to when it's at trial. But by the way, Judge, we're not at trial, but they attempt to apply that standard. They attempt to apply a standard of review on whether a conviction should be overturned. They cite things such as appearance of impropriety. I think that's a foregone conclusion that we have here. And then goes on to say, no, it's a standard of, well, is the person damaged? Is the testimony damaged? Is there harassment here? Is there an effect of the trial with unfairness? Again, citing cases that are relevant to a trial and saying that shouldn't apply, but by the way, it should apply, we should hold them to the standard, I don't think is a logical conclusion to come through. They selectively cite the preamble of Idaho Rules of Professional Conduct and leave out the portion paragraph 6 of lawyers should further the public's understanding of and confidence of the rule of law and justice system, because legal institutions in a constitutional democracy depend on the popular participation and support to maintain their authority. We have some other sites in the preamble which he also violates by derogatory comments of opposing counsel. I think if you go through, there's legal conclusions in their briefing that are not supported by the facts. They make statements such as there was no evidence presented of coercion or intimidation or these type of things. In fact, the one that really caught my eye just off of a few moments of reviewing this is they maintain that Mr. Wood did not tell this witness what to say. And one of the issues brought up with Dr. Davison on page 5 of the transcript, line 10, Mr. Wood says, "So what I want." There's just no way around that. There's just no way around that. He's telling this witness what he wants to hear. He's pouring his theory into this case of this witness. This is not a dead issue. There are other witnesses that have to be investigated now as a result of this. And so, Your Honor, I think it's well within the court's discretion, well within the court's authority in this case to disqualify Mr. Wood to protect the integrity of the process. I think when we look over the past 6 to 8 months and we take an opportunity to read the tea leaves, the riots and the objection and the protesting, demanding changes in the criminal justice system is the exact reason why we're here today. This is completely unnecessary. He had no reason to be in Hawaii as if he had to help the Maui police or prosecutor office serve warrants and arrest this person. He's made himself a witness by testifying what he personally reviewed and saw and the statements made. We also have no reason for him to be in Arizona. He had investigators down there from local authorities, from the FBI there to question this person. In fact, it's evidence that he didn't need to be there when he walks out of the room and by his own affidavit, the investigative process, the questioning of the witnesses was done by the investigators. By him leaving the room, he is showing that he had no business to be there. And then that goes to the idea that I think the court can conclude through a preponderance of this evidence presented that his intent to be there was to manipulate the testimony of this witness. And that goes to violations of the rules, violation of the criminal rules. And this court at the end of the day has to determine what kind of precedent it wants to set with this type of actions. If this type of behavior, in my opinion, goes unwarranted, unchecked, unsanctioned, you are telling myself, Mr. Pryor, the prosecutor, and anybody else who wants to cite this case in the future that you can engage in these tactics without repercussions. That is a dangerous precedent that I don't think any court or any witness or defendant would want to have. I would not feel comfortable engaging in this type of behavior. Justice should prevail. The only person here of these parties as a prosecutor, as a quasi-judicial officer, has a duty to ensure justice, and that was perverted at the least, Your Honor. Thank you.
All right, thank you for the closing. Mr. Means. Mr. Evans, would you like to present your closing now on behalf of this?
I would, Your Honor. Thank you. Your Honor, I'll note initially, counsel said our briefing is 13 pages of red herring. I noticed from counsel's briefing that there's not a single case offered in support of anything. There's no theory, there's no standard, there's nothing. They cite the Idaho professional rules of evidence that I'll get to in a minute, and they cite the Idaho criminal rules. Not a single case. The state's briefing, on the other hand, goes through an analysis of Supreme Court case, letter of law that the court has to follow. So with that, Your Honor, I want to start with the issues that are set out in their motion to disqualify. I think this is important. So there's 6. The first one, violation of the defendant's right to a fair trial. The second one, prosecutor violated the rules of professional conduct and the ABA rules. Number 3, witness tampering and intimidation. Number 4, the prosecutor is now a witness. Number 5, could be a future civil action. And number 6, there's Brady and Rule 16 problems. So I want to be clear, the grounds for the motion to disqualify are 6 things. And I want to lop off the low-hanging fruit. And I want to start first with number 2. So the prosecutor violated rules of professional conduct. The ABA. Your Honor will find on page 5 of our brief, Idaho law from our Idaho Supreme Court. In fact, Justice Moeller, a great Rexburg native, is the one that penned the decision in Kozman versus Dinius. That case very clearly states issues of sanctions of ethical conducts or violations of lawyers in this state is a decision for the Idaho State Bar, not the trial court. This is an Idaho Supreme Court case. The Idaho Supreme Court went on to say that we have designed a comprehensive scheme for submitting complaints and ethical violations, imposing sanctions where warranted, and for appealing those adverse decisions to the Idaho Supreme Court if needs be. Thus, I quote, the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar, close quote. Your Honor, we have a United States Supreme Court case that states in Strickland versus Washington regarding the ADA that those are just guides. They're only guidelines. They're not enforceable. Counsel has never shown one proof that we're under some obligation to follow the ADA guidelines. We can follow them if we want. There's no penalty if we do not. And so issue number 2, Your Honor, the prosecutor violated rules of professional conduct, which they've spent a lot of time on, is completely irrelevant. It's completely irrelevant, as well as the ABA rules. It couldn't be more clear, and I would challenge counsel to show me a Supreme Court case that says otherwise, because I've got 2. Your Honor, so that's issue number 2. Issue number 4, the prosecutor is now could be a witness in the case. I discussed this on page 7 of my brief. Again, I outlined the standard for the court. It's a compelling needs standard. The defense must show evidence that it's vital to a case, and you can't get this information anywhere else. So what do we have here? We have got a couple of exhibits with an audio recording, with a transcript, already a part of this court's evidence. And so why do we need Mr. Wood to testify to anything? Why do we need to have him called to do anything that we've got a recording of and we've got a transcript of? Again, it's a compelling needs standard. I outline, again, Idaho court cases that counsel does not. I outline these for the court that shows that he cannot be called as a witness. They have shown no compelling need. Again, it's their burden. They've got their 6 issues. They fail on the first 2 that I'm talking about. So that's issue number 2 and issue number 4, Your Honor. I'd like to turn to issue number 5. Mr. Wood needs to be disqualified because there could be a future civil action filed against counties. They provide no authority. They provide no evidence 2 days ago of what that is. They just claim that they need to be disqualified because of some future threat of a lawsuit. They're throwing things at the wall, praying that something sticks. The rule on that I cite in my brief, and we also have a ripeness doctrine problem with their methodology. It's not before the court. We can't disqualify somebody now based on whether or not a case is going to be filed in the future. I know that's black letter law. So again, their issue number 5 completely fails. Issue number 6, Brady and Rule 16. I'm not involved with this on the previous matters, as the court knows. It sounds like Mr. Mean was trying to bring up some issues of whether or not discovery. I don't know what that is. But as far as this hearing, as far as what's gone on and Mr. Wood's conduct to be disqualified, I haven't heard a single thing that would disqualify him because of Brady or Rule 16. You'll note I cite the law in the state of Idaho. I cite the cases that back that up. Everyone has a transcript and a tape of this matter. This is not an issue in this case. So, Your Honor, just a summary of those 6 issues, issue number 2, 4, 5, and 6, there is 0 issue at all with those being dismissed. They haven't met their burden, and it's their burden to meet, and they just haven't met any part of that. So what we're left with is the fair trial and then the witness tampering. No for the court, and by the defense's own witness, Professor Newton, prosecutors are supposed to talk with witnesses. Dr. Newton agrees with this. This happens all the time. Witnesses are different than jurors.
Your Honor, I have to object to the characterization that this happens all the time. I think he's implying that the manipulation of coercion happens all the time. I don't want to interrupt counsel, but that's a gross misrepresentation.
I'll overrule that objection. Go ahead, Mr.
Thank you. Thank you, Your Honor. Counsel doesn't like the words Mr. Wood used, or maybe the words that are placed in order that Mr. Wood used, but there's no coaching and there's no intimidation. I guess in my mind, I liken this to, and we don't know, with Summer Shiflett not being able to testify, we don't know what she knows or doesn't know. But I summarize this in an example for the court. So let's take a red light example. So if I'm a criminal prosecutor and there's a hit and run, and it's an issue of whether the light was red or green. And I have a host of witnesses that say that light is red. And then I have one witness that says, no, I think that light was green. So I bring that witness in and I say, all right, witness, everything that I show on it, law enforcement, all the other witnesses say the light was red, and you're saying that it was green. Here's the other statements you got to read. You can talk with the other witnesses about this.
Your Honor, if I may, I want to object to this proposed hypothetical. It wasn't included in the hearing. It's not included in his argument today. He's going outside of what he's presented to the court.
This is just argument, so I will overrule the objection. And
Your Honor, thank you. So back to my example, clearly prosecutors can't do this. We can't take a witness and say, everybody else has testified the light was red except for you. Here's the police reports, here's all this information. Mr. Wood did not do this. Mr. Wood at no time suggested to a witness what to say. That's just not what he did. Again, page 6 of the brief, Your Honor, we cite case law, Supreme Court. So let's assume this court says, well, maybe it's close to the line. So what's the remedy? The remedy is cross-examination. It's interesting, the defense's own witness, Professor Newton, said, well, you don't have to disqualify Mr. Wood from the case. Maybe we should have a taint hearing. And I outlined this in my briefing, and Professor Newton also outlines that in his briefing, but maybe we need to have a taint hearing to see really what Ms. Shiflett knows and doesn't know, and what the influence on that is. So again, we do not believe that Prosecutor Wood violated those rules. I want to go to the standard, Your Honor. I think this is important. I think we would all agree it's been difficult to figure out a standard in this type of situation. I believe we've come close, and that standard is held in Weaver. I put the analysis in the documents. In fact, I'm starting on page 9. So we call this the Weaver factors, and I cite the case law to it, but the court in Weaver suggests a 4-part test. And I think that's important to look at on whether or not a prosecutor should be disqualified. Now, let me just summarize some of these, Your Honor, for the court. So we already know the burden to establish the grounds for disqualification rests on the defense. The goal of the court is to shape a remedy which assures fairness to the parties and integrity to the judicial process. When a motion comes from an opposing party, those motions have to be viewed with caution. So I appreciate counsel's argument that that's my argument. Counsel's wrong. I'm citing an Idaho Supreme Court case that is actually adopted in the Foster v. Trial case that adopts the Court of Appeals case factors in Weaver. I outlined that starting on page 3 of the brief. Your Honor, I want to go through those 4 factors. So this is an Idaho Supreme Court case that adopted the Court of Appeals factors on whether or not an attorney needs to be disqualified. You'll note, Your Honor, it was in a civil standard case. It wasn't in a prosecutor's case. But I think the applicability still applies to lawyers. So let me just go through those 4 standards. Standard number 1, whether the motion is being made for the purpose of harassing the defendant. Obviously, the motion is being made by the defendant. Everybody's represented by the counsel. And so nobody is being harassed. No defendant is being harassed by Mr. Wood. The second factor to establish whether a prosecutor should be disqualified is whether the party bringing the motion will be damaged in some way if the motion is not granted. There's been a lot of argument, Your Honor, about the rules of ethics, about the Idaho criminal rules. There's not been one thing that I can remember hearing of how these defendants have been damaged in any way by Mr. Wood or Ms. Shiflett, frankly.
Mr. Evans, I want to back up a little bit to a comment you made talking about these Weaver factors.
Yes.
Did you indicate that the Weaver factors come from a civil case?
So this is, it is a civil case. In fact, you have that cite, Your Honor.
I think it's in the brief.
Yes, if you look at page 3, so what I've done in the briefing, cited the American Bar Association. Again, it's not authoritative, but the removal specifically of a prosecutor is cited there. I've cited matters as close as I can get as far as disqualifying a prosecutor because of conflict of interest. Then I also have the Weaver factors that I think it's a disqualification of a lawyer, Your Honor.
I understand. The Weaver factors, I guess, getting back to this first factor you just went through pretty quickly, was question whether the motion is being made for the purpose of harassing the defendant.
Right.
And if this comes out of a civil case, then would that not just be better to say the opposing party?
That's correct, Your Honor.
The answer is the motion's being made by the defendant, so of course that wouldn't apply, but if you looked at this in a context of this case, and we're looking at the opposing party, isn't that more accurate to state that it would be to harass the opposing party, not necessarily defendant as defined a criminal defendant, whereas in a civil case, a defendant could just be the other party?
I agree with that, Your Honor.
Okay, thank you.
Your Honor, so the second factor set forth by Weaver, and again, this is as close as I'm going to be able to get the court, and I've spent quite a bit of time over the last couple of days looking at this. But the second factor that I've talked with before was the party bringing the motion will be damaged by some way if the motion is not granted. I think I've reviewed that. I've provided the case law on that portion for the court. A couple of other comments from me regarding that. There's no evidence from Ms. Shiflett that she was intimidated, threatened, or coerced. There's no evidence of that. She was represented by counsel. Her attorney never objected to anything that Mr. Wood said. And the defendants, again, have shown no damage to their client in any way if Mr. Wood stays on the case. So I'll move to the third factor that establishes disqualifications of lawyers in the state of Idaho. And I want to spend some time with this, Your Honor. So whether there are any alternative solutions, or is the proposed solution the least damaging possible under the circumstances? And I want to use the defendant's expert witness of Dr. Newton, because the court will recall, I spent quite a bit of time asking him the questions on this. And the question is, okay, what is the remedy? And so Professor Newton discussed some of those. And we already talked a little bit about the pre-trial taint hearing, is what he called it. That is set forth in his briefing, page 17 and 18, paragraph 62 and 63. And what I understand that to be is the court could determine, is she going to be called as a witness? And what, if anything, is going to be false or inaccurate testimony in the case? So other potential alternatives is not allowing Ms. Shiflett to talk in trial or limiting that communication. But in the case, if this court finds any questionable conduct, one of the factors the court has to consider is, okay, what is the solution that's going to be least damaging in the situation? I note, and the court notes, there's not a single one of the defendant's experts, all were asked if they know of a single case in a situation like this where a prosecutor was disqualified by a court. I don't know that. The defense experts had no idea. I mean, there's not a single case that leads that to believe. So I assume that perhaps in those type of situations, courts are finding alternate solutions short of disqualification. So again, the third factor of Weaver, also adopted by the Idaho Supreme Court, to establish the disqualification of a lawyer. The last factor, Your Honor, whether the possibility of public suspicion will outweigh any benefits that might accrue to continued representation. Again, Your Honor, the burden is upon the defense. They claim quite a bit of information of, well, we didn't call it as well. It's their burden. It's their burden throughout. The Idaho Supreme Court has said that very directly. So their burden is upon them to show any public suspension or suspicion. None has been offered in this case. Ms. Shiflett is not Mr. Daybell. She is not Ms. Vallow. She's a potential witness in the case. And there's no evidence to present that Mr. Wood directed her to say anything other than tell the truth. So, Your Honor, based on those, and again, we're trying to provide the court some information of what to go through, but every single one of those 6 factors, the state's briefing identifies the legal standard and the cases and the analysis for the court to consider. We would encourage the court to look at that prior to making its decision. I'm sure we probably found a lot of the same things. Let me just summarize with this, Your Honor. These motions are made by someone other than a former or current client, which heightens the scrutiny, justifiably so. Motion to disqualify in the state of Idaho are disfavored. They must be viewed with caution. The burden is upon the defense. Our argument is the Weaver factors. And again, I outlined some more that are the criminal factors. I outlined the ADA rules. Our assertion is Mr. Wood did not violate those factors. And even if he came close with those factors, this court has the ability to structure a remedy, just like the defense's expert says. You don't need to disqualify Mr. Wood. There's a remedy for this. And the court's fully within its capable powers to be able to do that. All the defendants are represented by attorney. Their rights are all protected in this. And again, the remedy is not to disqualify a prosecutor. We have a trial in 7 months, Your Honor. I cite the Supreme Court cases on the dissipation of things that occur now versus trial. I think that's important for the court to consider, is if there's a taint, even if there is a taint now or a taint on October 1st of 2020, where is that going to be in 7 months? We have court cases, not summations, not guesses. We have court cases. They outline to the court what those are. We cross-examine the witness if they've been coerced, if they've been doing again, courts have said the appropriate remedy for this is to cross-examine, or there's alternatives, exclude the witnesses, those types of things. So, Your Honor, based on this, based on the law in the state of Idaho, based on the law in the Supreme Court of the United States, and what we have presented to you, there is not a way to disqualify the prosecutor, Mr. Wood, from this case. Thank you.
All right, thank you, Mr. Evans. Counsel, I'm going to allow for rebuttal argument. Before I do that, I'd like to take a brief recess to allow mostly for the court reporter to catch her breath here. And so I'll let the rebuttal arguments be made after that. I've got 2:55, so let's come back on in 15 minutes at 3:10, if that works for everyone.
That works for me, Your Honor.
All right, we'll take that 15-minute recess. Thank you.
Thank you.
All right, looks like everybody's here after our mid-afternoon break. This is the time on this hearing where we are at the point of rebuttal argument, if any is requested. Mr. Pryor, I'd let you have your rebuttal first, and then Mr. Means in order of your closings. So Mr. Pryor, any rebuttal? And again, I'd ask counsel to not reiterate their closings, but just any rebuttal in light of the prosecution's argument. Mr.
Judge,
Pryor.
the first point that the prosecutor made is that somehow the Idaho rules of professional conduct don't apply in this case, and that it's the job of the Idaho State Bar Council to determine whether there should be any sanction for behavior. That is wholly and entirely inaccurate. A court, and there's a Supreme Court case, and I apologize, Judge, I don't have it at hand, but there is a Supreme Court case that is directly on point that says it is the inherent power of the court to take basically the job of being the gatekeeper of all the proceedings. Now, in this case, Judge, the allegations are Mr. Wood manipulated, intimidated, coerced, coached, whatever term you want to use, a material witness or a witness in this case. He affected and involved himself to an extent that it created a problem for us to have an impartial and fair trial for Mr. Daybell. It is not up to the State Bar to make a decision on that, Judge. It's up to the court to make the decision. Now, what it is up to the Idaho Rules of Professional Conduct to do is to guide a lawyer in how he's supposed to conduct himself. And he's guided by the Idaho Rules of Professional Conduct and the rules that guide a prosecutor. Now, under 8.4, it tells you what misconduct is. And rather than go through it and belabor this point, Judge, it's very clear what misconduct is under 8.4 of the Idaho Rules of Professional Conduct. Mr. Wood's actions cannot be described as anything other than a violation of the Idaho Rules of Professional Conduct. He purposely and intentionally disparaged another attorney. He disparaged a defendant, and I agree with Mr. Means. He slightly disparaged me and slightly disparaged Ms. Vallow in his references. He used his authority as a prosecutor to manipulate and intimidate a witness. It doesn't matter whether it had an impact. Now, regards to the Weber standard that he's applying, what the prosecutor is attempting to do is throw a lot of cases out there and say, let's see if anything sticks. He talked about defense doing that, but that's exactly what he did. Because Dr. Newton expressly said there is not any case on point that directly shows what the standard should be and how this should be applied. But it's not a heightened standard, Judge. If we apply a heightened standard to everything that involves what a lawyer does in a case, there wouldn't be any discipline. And you don't draw an analogy in Weber because that was a trial, and during that trial, these things were conducted. This is a completely different situation. This is a case that before a witness gets in front of a police officer and before she gets to testify, this prosecutor spent 20 minutes massaging his theory. Now, Mr. Evans said, Mr. Means never said to Ms. Shiflett what to say. I beg to differ. And I asked the court to go back to the transcript, go back to the tape recording, and hear Mr. Wood in his own words, this is what I want. This is what I want. So quite honestly, Judge, he did say what he wanted Ms. Shiflett to say. I can't even fathom how this is not in any way a violation of the numerous rules of Idaho Rules of Professional Conduct. In regards to a criminal statute, Judge, it's a very broad statute. And as a defense attorney, I understand and I advise all of my clients that in no way should you do anything that could be construed as influencing, inferring, suggesting anything to a witness when you're a defendant in a case. And the fact of the matter is Mr. Newton, Dr. Newton, excuse me, Dr. Davidson, and Garrett Smith, all of them said, there is no doubt that this is coaching, this is influencing, and Judge, if it's coaching or influencing, Mr. Wood violated a criminal statute. Now, in conclusion, this pretrial taint hearing, Judge, I'm going to suggest a pretrial taint hearing too, Judge, But that's going to be after I suggest my remedy that Mr. Wood get removed from this case. And I reiterate, I want him removed from this case. And then I'm going to gather every witness that's involved in this case and request the court do a pre-taint hearing on every witness. And Mr. Wood will be called and subpoenaed as a witness in every one of those pre-taint hearings.
I'm going to object. This is off what we're talking about today.
Oh, we talked about Judge, we talked about a pre-taint hearing, and I get to address that.
You can address that, but we are just, well, it's part of your argument. So go ahead, Mr. Pryor.
And Judge, I'm going to call all of the witnesses, and I'm going to call Mr. Wood, and I'm going to get him on the stand under oath, and we're going to talk about what was discussed. Because quite honest.
But Mr. Pryor, this is not really argument now at this point. You're just indicating a procedure you're going to follow in the future. So please just keep it to a legal argument, if you would.
Well, the procedure simply is a reason and a justification for what has transpired here.
I understand.
As all due respect, as Professor Newton expressed, Mr. Wood got caught. And because there isn't any case law is because it's the rare situation that a prosecutor would be so audacious and so arrogant to engage in this kind of conduct. And I find it outrageous. And my experience, and I hate to say this, is because I don't want it held against me in the future in Ada or Canyon County, but the prosecutors that I deal with in Ada and Canyon County are incredibly reputable, distinguished, and responsible prosecutors who take their job very seriously. And I can't understand how a prosecutor in a very high-profile case could even consider engaging in this kind of conduct. And it can only be attributed to the arrogance that he thought he could get away with this. He got caught. And I want some assurance from the court at some point that none of the other witnesses have been influenced this way. None of the other influences have been subjected to Mr. Wood's version of meet and greet. And I'm not sure how we're going to do that. But the first step, Judge, is to remove him from this case, because there is no other way you can assure my client, Mr. Daybell, is going to get a fair trial. Thank you, Judge. Thank you.
Thank you, Mr. Pryor. Mr. Means, any rebuttal argument?
Yes, Your Honor. Thank you. A couple things. In looking at the transcript that was admitted with this court, it's clear and beyond question that the statements of the prosecutor to this witness were intended exactly to get what he wants to hear. He says things such as, but I kind of want to give one thing I'm going to kind of ask you to consider. So what I want to kind of tell, and then what I kind of want to give you. I mean, these are all that the court can review these things, but there is no question. And the argument by the prosecution that the legal conclusion is that there is no evidence showing coercion or tampering or coaching or whatever standard or whatever one we want to throw is completely unsupported. The only evidence that was introduced at the trial is the exact opposite of that conclusion. There is no cross-examination or no counter witness or anything that supports the conclusions other than Dr. Davison, Dr. Newton, and the arguments that have been presented. So the court, in considering the evidence, is pretty clear. I think part of the mention or part of their brief that I mentioned before, red herrings, is pretty obvious on their argument. You cannot argue the ABA applies and then it doesn't apply. You cannot argue that the test applies, but it's limited to trial. But by the way, judge, apply this same exact test. You can't argue that the Weaver applies in a civil case with a civil attorney when a prosecutor has a higher duty of ethical standards to ensure justice as a quasi-judicial officer and compare that to a typical incompetent civil attorney. You cannot argue that Rule 16 that object to the argument and then argue in your brief that it hasn't been violated. If we look at Rule 16 by opening from their argument and their oral argument on page 8 of their brief, it's real clear. Rule 16A, mandatory disclosures of a prosecutor. A prosecutor must disclose to the defendant information in the prosecuting attorney's possession or control, or that later comes in the prosecuting attorney's possession or control that tends to negate the guilt of the accused or the offense charged, or that would tend to reduce the punishment for the offense. When we look at the recording and the transcript submitted in this case by stipulation of the parties, the prosecutor expresses his own opinions that there is information and evidence that he has that negates and potentially affects the punishment for my client. This information was withheld and has not been produced absent the recording that we received and provided to the court. That is clear. When we flip over to, in the same rule portion of 6, state witnesses, down toward the middle portion, the rule says the prosecuting attorney must also furnish on written request, which we've requested multiple times, the statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents or to any official involved in the investigation of the case, unless a protective order is issued. There is no logical argument that the 18-minute conversation that this prosecutor had with Summer Shiflett are statements by this witness. And again, we would not have this without production from Mr. Garrett Smith. It was not included in discovery responses. It was not produced despite it happening in October and this hearing now happening in January. The prosecutor, even if he didn't record the hearing, held in his hands statements by this witness. He had multiple opportunity, resources, and the sole obligation of everybody involved in this case to produce these witness statements. He withheld them despite his opportunity. He provided discovery responses on or about December 2nd of 2020. In no way are these statements by this witnesses included in those discovery responses. They were withheld. That end of Rule 16 allows this court to issue appropriate sanctions as a result of those violations. I think the sanction has to be at this point in time, when combined with the other issues here, disqualification from this case. And then if we finally look at Rule 8.4, misconduct of the Idaho rules of professional responsibilities, there's a violation of A, B, C, and D. This prosecutor engaged, if you look at D, engaged in conduct that is prejudicial to the administration of justice. No question about it. In C, engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation. Committed a criminal act, and then it goes on. Violates or attempts to violate the rules of professional conduct. So the standard on 8.4 is not even did he violate the rule, he attempted to violate the rule. These are all problems that I think fall well within the discretion of this court to order Mr. Wood be disqualified from this case. Thank you, Your Honor.
All right, thank you, Mr. Means. That'll conclude the arguments on the motions. Council, I'm going to take a little bit of time here to get my thoughts together on a ruling. I am prepared to make a ruling on this afternoon, but I need a little time in order to put that together. So apologies for dragging this out potentially longer than necessary, but I'm going to take a break for about an hour and then we will come back on the record at 4:30 and I'll make a decision at that time. So we'll be in recess until then.
Thank you, Your Honor.
Thank you.
Noon Crime Talk aficionados. Thanks for sticking around and joining us. As we just heard, Judge Boyce will be collecting his thoughts before he gives his findings of facts and conclusions of law regarding the hearing, as well as the closing arguments that we heard from John Pryor, which is obviously Chad Daybell's attorney, Mark Means, Lori Vallow's attorney, and then Mr. Troy Evans, who has stepped in to help defend, I guess we can say, not really defend, but argue against the motion as it relates to the motion to disqualify. Now, I have said this before. When you start making allegations and accusing not only just another attorney of unethical conduct, but of accusing a prosecutor of unethical conduct, you better have your ducks in a row, and you better be absolutely certain of that. And my opinion, and we'll see if I was correct or if I'm completely wrong in this particular case when Judge Boyce issues his ruling. I've read the transcript. I listened to the tape. There's nothing, in my opinion, that amounts to witness tampering, making a witness suggest anything, to use their words, coercion, manipulation, coaching, and influencing were words that Attorney Means used repeatedly to describe the interaction of these contacts between Miss Shiflett, who is Lori Vallow's sister, who contacted the police so that she could tell the police what she knew. She brought her attorney to the conversation. The attorney, Garrett Smith, recorded the conversation, didn't tell anybody that he was recording the conversation, at least in this particular scenario, but he didn't object to anything going on at that time. I'm really not sure what was inappropriate here. Was it an introduction? Yes. Did he say a lie? I want you to say this. Hey, do you know anything about this particular subject? Hint, hint, wink, wink, nudge, nudge. No, there was nothing there. This is a niece, or I'm sorry, the aunt of these children that are now deceased and are subject to the charges, JJ and Ty Lee. And in this particular situation, he's being, for lack of a better term, hey, I'm the prosecutor in the case. I understand that your sister is in a tough spot, but he basically says she's going to have to pay the consequences for what we believe that she did. We also think that maybe she's being manipulated. It'd be great if she talked to us, but she's not. He can't do that. He didn't say, go tell her to cut a deal. There's nothing there. So in my humble opinion, and like I said, we'll find out here in about an hour whether I am correct or whether Attorney Pryor and Means are correct and that Mr. Woods should be completely disqualified from this case. Bottom line is, I just don't see it. Let's see, as it went through this arguments by Mr. Troy Evans on behalf of the government, the motion to disqualify, they're basically saying it's going to result in an unfair trial. I really don't see how that's going to result in an unfair trial. These witnesses, this witness is going to be there. She interviewed for hours with other police officers in that hearing. What is appropriate is a thorough and extensive cross-examination of this particular witness if the defense thinks that she is somehow not being truthful and providing a complete recollection of what she knows or doesn't know. It's not to disqualify the prosecutor in any way. Violation of the rules of professional conduct. Attorneys are bound by the rules of professional conduct. There are rules that guide us. Some are much more straightforward. Others have a little more leeway. I simply do not see anything that Mr. Wood did that was inappropriate. And frankly, as a defense attorney, if I thought it was inappropriate, I would say so. I would be all over that. Just because you don't like what the DA is doing, i.e. prosecuting your client, doesn't mean that he's doing anything unethical. And when you start throwing the big E word around against another attorney, I'm telling you, you better be right. Because if not, if you are accusing attorneys of unethical conduct and it's found not to be, guess what? You are the one that could actually be grieved. It's just, I just do not see it. This was somehow witness tampering, and Mr. Means tried to say, well, there was language in there that says, I would like, this is what I want. Yeah, I want to get this. I want to get this evidence. But he knows that she's not the witness to do it. Mr. Woods indicates on that transcript that he has heard the telephone calls between Lori Vallow and people, not their attorney, that he thought that she was going to maybe want to talk, maybe cut a deal, maybe explain to the prosecution where the children were at that time, what happened to them. And then somehow he says, looks like, Chad Daybell stepped in and, sort of tried to influence that. He said he's not a good guy. Guess what? I'm sure if you sat in on interviews with district attorneys and victim advocates that go and talk about the family, say, these are the charges. The defendant is, done this, this, and this. We think he's a bad guy. We think he needs to go down on this. Is that unethical conduct? No. It's probably even telling the family what they already think if they're the victim of that particular defendant. The prosecution, I think, correctly rebutted a couple of these issues very well. There was no there was no witness tampering. Easy for me to say. Next, that the prosecutor's now become a witness. No, if the prosecutor had become a witness, that would be a circumstance where, let's say, he one-on-one has a conversation with a witness. He maybe memorializes the statement. He's the only one there. Most prosecutors are smart enough not to do that. And then the witness says, that's not what I said. Well, at that point, yes, the prosecutor could become the witness. But guess what? Here we have the attorney who was present. We have no indication whatsoever that Ms. Shiflett is somehow recanting her statement. We have Garrett Smith, the attorney, who's also present, who recorded this. It's more than likely he could come, authenticate it. And if there's issues regarding what was said, that would be the case. But here we're not talking necessarily about a material witness. If Ms. Shiflett had said that Lori Vallow confessed to me and there were only two people present, and then she denied it, i.e. the two people were only Ms. Shiflett and Mr. Wood, then there would be an issue for that. But I simply don't see it because the prosecutor is not a witness in this particular case. The argument that the defendants may somehow file a civil action against the county because somehow Mr. Wood, I'm assuming, violated somebody's civil rights. I'm not really sure how they're going to make that claim. I think that's ridiculous. The Brady and Rule 16. Bottom line is, yes, the government has a duty to turn over what they refer to as Brady material. Brady material is anything that would reduce the culpability of a defendant. Well, guess what? Is there anything in that statement that somehow says Lori Vallow is innocent? There's nothing in there. It's an introductory comment. Like I said, maybe I'm wrong. Maybe this judge will have a much stricter standard throughout this and perhaps disagree with my conclusion. I think if most people are shocked and outraged, some of these, the expert witnesses, we had was it Dr. Newton, Dr. Davidson. He was the psychologist who was saying, oh, this use of these terms was there to simply influence the witness and get them to do this and suggestibility, blah, blah, blah. Okay. So the defense doesn't like what Ms. Shiflett's going to say. Cross-examine her on that. That's it. That's how I would handle the situation if I were the judge. Then we had Dr. Newton, who's the guy that teaches the class on professional responsibility. And forgive me if I'm wrong, but I think he's a law professor. Nothing wrong with law professors, but there's a lot of things they teach you in law school that don't have a whole lot of applicability as it relates to actually practicing law. In a perfect world, what is a prosecutor supposed to come and say, hi, I'm the prosecutor on the case. I can't talk to you about anything but tell the truth. That's it. No, prosecutors are constantly communicating with victims of a case, particularly in a case involving any kind of death. They become very close. I've seen prosecutors get invited, to weddings because they spent so much time with the family. They're there to console them. They're going through a loss. They're not robots. Okay, there's nothing in that particular interaction. Like I said, in my opinion, we'll see if the court disagrees. I don't think they're going to, but if I'm wrong, I guess everyone will let me know. Hey, Scott, you got it wrong for sure. The language that was used in this closing argument by Mr. Pryor and Mr. Means, oh my gosh, basically saying that Mr. Wood got caught. He's lying, cheating, coaching, and intimidating a witness before a trial. Bold words, no doubt. And I don't think that is supported by it. And if Miss Shiflett thought that she was being bullied, intimidated, coerced, pressured in any way, don't you think the first witness the defense would have called to support their motion would have been Miss Shiflett? And she would have said, he talked to me. Wow, he put this mesmerizing spell on me, and I had this recollection of things that didn't happen, and I wasn't truthful. And it was all because of this conversation. Don't you think they would have done that? Hell, they had the attorney for Ms. Shiflett, Mr. Garrett Smith. He's not running up and down saying my client was intimidated. He said the conduct he thought was unprofessional. Guess what, ladies and gentlemen? People talk about attorneys. The defense bar knows who the lazy prosecutors are. The prosecutors talk about who the defense attorneys are that haven't tried a case in years. Okay? They know the guy that will go to trial, the attorney that will go to trial, whether it's prosecutor or defense, and those that will not. And there's nothing in there that is not inaccurate. He says he states an opinion. The guy's not competent. When he's not running around calling me a liar, okay, which is all true. Mr. Means previously had said that the prosecutors were out there trying to do terrible, evil things, listening to their phone calls. Bottom line, I just think this is over-the-top conduct by the defense. I think the defense needs to be very worried. The case will go on, and I would expect that at the end of it, there would be a grievance based upon what was been alleged. You don't go around accusing prosecutors of committing crimes unless you're absolutely certain and you get it right. And we will have to wait and see what the judge ultimately rules. But I simply don't see it. And in this particular case, I thought Mr. Evans laid out rather clearly. Now, the burden is on the defense. The burden is on the defense because they're the ones bringing this particular motion. Just like when a prosecutor brings a charge or allegation, it is their burden to prove it beyond a reasonable doubt. Here, the burden is on the defense attorneys to convince the judge that there was such misconduct such misconduct that his client's right to a fair trial had been somehow tainted in some particular way, and that the rules of professional conduct were completely ignored, and that involved witness tampering. And the only way that we can go forward is if the prosecutor is a witness in this civil case, or in this case. And oh, by the way, Judge, we may sue everybody. For what kind of cause of action? I'm simply puzzled as to what they would try to bring a civil case on. Disclosure of information regarding Brady and Rule 16, which are the rules of discovery. Mr. Means tried to bring up that he's, somehow wanted all this other documents turned over and supported. But the reality of it is, the judge interrupted him and said, "Hey, have you filed a motion to compel yet?" "Well, I'm going to, Judge." Well, you haven't yet. And maybe there's a reason why he hasn't produced any documents, because you've attempted to disqualify him. That kind of puts everything kind of on hold here. And I don't know. I'm telling you, if I thought that a prosecutor had done something questionable, if I thought that if I was the attorney in the case, if I thought a detective had done something questionable or unethical, guess what? Unless you're going to get a motion to suppress granted because of what a detective did, you save it for cross-examination. You save it at trial. I have many times when I've had witnesses that refuse to talk to my investigator and myself, I say, we've never talked. And in fact, I've tried to talk to you on several occasions. You refuse to do so. You remember that, witness? Yes. Well, since you wouldn't talk to them, let's talk about how much time you've spent with the prosecutor in this particular case. And usually there's an objection. The judge will say, "No, fair game. What'd you do to prepare for your testimony here today? How many meetings have you had? How long of those meetings have you had?" And sometimes they maybe give you a phone call. "Oh, and it wasn't documented." Oh, you're going to make more of hay out of that as a defense counsel in front of a jury at court if you can show that you think the prosecutor was somehow doing something shady. But from here, I'm of the opinion I don't think Mr. Wood did anything inappropriate. But guess what? If I was the prosecutor, and assuming Mr. Wood wins, I would be like, war. War has been declared, if it hasn't officially been declared already. When you have two attorneys that are accusing you of criminal conduct, being unethical, I'm telling you, I would go to war with those individuals. And it would be done professionally, but no professional courtesies, no favors whatsoever. I would crush them, and I would let their clients know that, bottom line is, hey, I'm going to do everything I can. If your clients would like to have an offer, you come talk to me. But from here on out, it's nothing but GORT. And that stands for guilty or trial. Bottom line, okay? You plead guilty to everything, or we're going to trial. And I would do that. And the defense or the prosecution should say, "I'm going to give you everything you want, and guess what? And I'm still going to convict your clients." One of the arguments that the defense counsel brought up was that the prosecutor somehow went down to these interviews down in Arizona at government expense. Well, of course it is. He's doing his job. Of course it's state expense. Because she reached out. It is not uncommon for a prosecutor to be involved in a case to judge the credibility of witnesses. Is what this witness telling me? The prosecutor probably has a greater understanding of the nuances of the case than the detective, particularly one in Arizona. I'm assuming the one that they talked to was from Idaho. but the prosecutor can be in the room. I've sat through many an interview, and it's not uncommon, particularly in bigger cases, where the prosecutor is there throughout. In most federal investigations, if police are interviewing somebody and they have an attorney, the attorney's there, the prosecutor's there. And if somebody's smart, they say, you better get somebody here with some authority to actually cut a deal if that's what they're looking to do. Somehow the defense was shocked and outraged when warrants that were basically being issued by Idaho through Hawaii to search the residence of Chad and Lori when they're in Hawaii and they're there to search, but the police are there. Not uncommon. Do you think it's uncommon if there's a homicide case and the on-duty prosecutor gets a phone call and says, hey, this is a big one, you better come on down? And they get out of bed in the middle of the night and they go down to the crime scene and they're there to gauge the scene to get it. I can tell you, just yesterday, I was out walking with my investigator at a crime scene. That's what you do. You go to the scene to get a feel for it, to see what's going on. And you're going to be there to supervise the nuances of the case. As it was characterized by Mr. Pryor, this is one of the biggest cases, if not the biggest case in the state of Idaho. You think the prosecutors want to make sure they do it right? That's right, they do. Do you think that they're there to supervise? Absolutely. If there's a legal issue that comes up, what's the best way to do it when you got a 4-hour time change between Hawaii and Idaho? You have the prosecutor there. I just don't understand where the outrage is coming from. And I'm a defense attorney. I like to root for the defense. I like to root for the underdog, the guy that is charged. But I said it early on. I just don't think this motion had merit. We'll see. We'll see if I'm wrong in when the judge gives his ruling. I think the judge will say, there's no dispute as to the conversation, that a conversation took place, but there's nothing to indicate here. And I think the court will ultimately say that the defense has not met their burden to show that Mr. Wood somehow did anything wrong, criminal, unethical, or has made himself a witness in these particular proceedings. Now, this Judge Boyce seems very smart. And although I'm a firm advocate that cameras should be in courtrooms, in situations like this, I think it makes people more talkative, more verbose when they talk, because they are perhaps doing it for an audience that they think is out there. I think most of these closing arguments could have been wrapped up in about 10 minutes or less. The prosecutor, I thought, was frankly much more succinct in his argument. He laid out in his brief, they keep saying that we haven't presented any evidence, but what other evidence is there? You got the affidavit of Mr. Wood saying I've done nothing wrong. You have the recording that's been admitted into evidence. You've had two experts testify specifically regarding, one saying, we think it was coercive, the language. If you look at the language, they talked about the re-interrogation techniques, which is basically the investigative technique that's been used and kind of gone in disfavor over the years because, when there was usually a confession or something along those lines where somebody did something, they confessed to it, and then it turned out they didn't actually do it, usually the re-interrogation techniques. There's nothing to indicate that Mr. Wood was using the re-interrogation technique whatsoever. The re-interrogation technique is to go in and talk to somebody, explain, hey, you're a really good guy. Sometimes things happen, we're accusing you of A, but you know what? You may not really have done A. What you really may have done is B here. And you're a good guy. Maybe we can get you some help if you need it. And next thing you know, so the guy basically is confessing, well, yeah, I did do B. Oh, really? Well, if you did B, you probably did A, and thanks for confessing. So it's just kind of a way of befriending somebody to get them to say something that isn't true, or to get it out of a witness. But there's nothing that would indicate that that's what was actually going on. But I digress. So this Judge Boyce, he seems very smart. I looked him up. It looks like he was in private practice. He was a magistrate before he was a district court judge here. And I think he's trying to give everybody the opportunity to have, lack of a better term, their day in court, make the record. But I thought that at points, maybe it's just, I never met the man, so I can't say, but it looked like he was getting a little frustrated by the repeated conduct. One of the things you do as a lawyer is if you have briefed everything, you've written it out, and you filed it with the court, as a general rule, you don't go back over it line by line if the court has it there. Provide something new. Provide some argument regarding maybe a little nuance that you'd like to highlight. But don't just regurgitate what you just said in your filings. So we'll go, that's just kind of a practice tip. I think that most judges are like, if I've read it, I have it. Don't just tell me again what you just filed. Oftentimes in those situations, when you file the briefs, you simply say, Judge, I've submitted it. I know you've read it because you're a thorough and prepared judge. Do you have any questions? If not, I think I would just like to leave this particular point. Sometimes less is more. But to go back through and start, most judges I know do not like it and get very offended when other attorneys start throwing the E word around. It's just not something you do professionally. It's just not something you do. And if it does happen, then you take the appropriate action. I've had to report one attorney to attorney regulation, and that was years and years ago, but I had a client. She cooperated in a case, and there was two attorneys on that case. One was kind of, he was getting a little older, and the other guy, I knew him. I knew him well. And it turned out that the older attorney sent an investigator to talk to my client because she was still talking to somebody in that little clique, and she agreed to basically, change a statement. And it all came out. And of course, the prosecutor went to me like, why are you letting your witness talk to I'm like, what the hell are you talking about? And it turned out that this other attorney had talked to my client without my permission. You don't do that. You just don't do that. It's unethical. And I had to file a grievance. And I remember, regrettably, I have to file this against another attorney, blah, blah, blah. But the other attorney we kind of brought in to help for the trial that wasn't aware of it, but he had to be grieved as well, said, Scott, you did exactly what you're supposed to do. But you don't throw those words around. You don't go into court. And I never said, oh my God, Judge, this and that. But the judge said, well, I'm sure you'll file something with the appropriate people that you had to do that. And like I said, you just simply do not sling those words around. Are there people that I think that are unethical attorneys? You betcha I do. But unless I have some direct evidence, am I going to do this? No, you don't do it. Do I think that there are prosecutors that played hardball? If Means and Pryor are offended by this conversation, I could show you some, tactics that prosecutors have really taken that even then is not rising to the level where they're going to get disqualified. I once had a case where a prosecutor was prosecuting my client, and maybe hypothetically before I got in the case, maybe he charged at an aggressive manner at the district attorney, and he was charged with threatening a prosecutor. And we got appointed, and so she was obviously a victim in one case, and a prosecutor in the other. And I'm like, hey, you can't do that. It's gonna affect your ability to be fair on this case. There may be a deal. You got to get off. And the district court judge said you can't be both in the same office. Just put a special prosecutor on. Why are we doing this? It got appealed, and unfortunately, never got resolved because the client passed away. So, I mean, there are, like I said, if this is what the attorneys in Idaho, and maybe that's a good thing for Idaho, but if they think that is somehow criminal conduct, intimidation, all the things that they're alleging and throwing some serious rocks and arrows at Mr. Wood, they haven't dealt with some of the prosecutors I've dealt with over the years. But I bet you if Mr. Wood does not get removed from this case, stand by. He is, I would not talk to either one of these attorneys in anything other than written communication, so that there's no way that they're going to accuse Mr. Wood of anything as far as misconduct. And the argument that somehow they're going to have a hearing based upon every introductory interaction that the prosecutor or police department, I mean, why stop with Mr. Wood? What about the police? When they talk to people and they, hey, how you doing? Come on down, blah, blah, blah. Hey, we're going to talk with you. All that stuff. And my guess is if these police officers were really good, these detectives that did the interview of Ms. Shiflett, they're going to say, all right, you understand we're recording this conversation here today. You're doing this freely, voluntarily. Yes, I am. Yes, I am. Has anyone threatened you, made any promises to you, done anything in any way to get you to basically change your testimony or not tell me the truth here today? I would bet that was the introductory comments made by the detectives. And where's the taint? Like I said, where is any misconduct? Like I said, anything's possible, and sometimes the courts shock and surprise you. But in this particular situation, I would be shocked if Mr. Wood was kicked off the case. Peggy, Scott, what happened to your forehead? Good question. I think that comes from stress. I was in a court hearing this morning, and let's just say things, witnesses turned from what they had previously said, and let's just say there was a little tension in the room, and I don't know why, but apparently when I get probably if these blood vessels pop, maybe I'm not having an aneurysm or something, I guess. But yeah, I didn't have them when I left the house this morning, that's for sure. And it was only one hearing today that got a little contentious. So that's probably why, like I said, got a couple of blood vessels there because my head was about ready to explode, apparently. So yeah, that's what that is. I was trying to hopefully, think that nobody saw anything, but let's face it, everybody does it. And we don't do our makeup here at Crime Talk. This is just the lovable face that you get here all the time, good, bad, and ugly. Just the way we kind of like to bring it to you, in all of these cases, because, we talked about this the other day. I mean, just because you want something to be true doesn't make it true. Just because you committed to one particular side doesn't mean that, the other side is always right and you're, or they're always wrong and you're always right. There are gray areas for sure, but, you have to look at it objectively. And I just would be very surprised. Somebody sent me something from, it was another channel. I think it was like a court TV or whatever. And they're experts, basically were, oh my God, this is the worst thing ever. This is just terrible, terrible, terrible. And like I said, I if I had that transcript and I thought that there was something inappropriate, I'd want to bring it up at trial. Now there's going to be so much stuff going on to try and limit anything that goes on. And let's face it, why do they want Wood off the case so bad? You have to really wonder why. Is it because they think they did something unethical? Okay, apparently the defense, that's the grounds they're staking out. But prosecutors tend to stick together. And even if, let's say Mr. Woods did get excluded, you think it's going to somehow change the complexion of the case? Probably doubt it. Normally when a prosecutor gets disqualified, they have like these agreements, like if we need a special prosecutor, we'll be yours. And if you need a special prosecutor, we'll be ours. And sometimes you have to consider, who am I going to get if I get this prosecutor kicked off, or I move to, change a venue or something along those lines. You have to be careful what you wish for sure when you do that. But somehow, and I know Mr. Pryor isn't thinking this, but I think they're trying to make the leap that if Mr. Woods was so bad, violated my client's due process right to a fair trial, Your Honor, the only remedy would be to dismiss these charges. They didn't say that, but that's kind of what they're leaning towards. No. As the prosecutor, Mr. Evans, outlined in this court, to the court in his arguments, is that there are things that even if a judge thinks a violation has been done, unless it's so egregious and outrageous, you're supposed to tailor a remedy that is the least severe possible in any particular way. Kind of a classic example of that is if there is a case and a witness says something that everybody knew that the witness shouldn't say, and it potentially could result in a mistrial. Say, for example, the police officer on the stand is like, well, and I was aware of his prior criminal history. Objection. When we approach judge and move for a mistrial, the judge probably isn't going to grant you a mistrial just because of those particular words. He may admonish the witness. He may instruct the jury that they cannot consider this in any way whatsoever. But they're probably not going to grant a mistrial because a mistrial is an extreme remedy, just like removing a prosecutor is a very extreme remedy. I just don't see this judge taking that leap in any particular way. Let me see if I can read some of these questions. Okay, I agree. Carol there. Yes, why do, you have to ask us, why do they want him off the case so much? Is it because he's an experienced prosecutor? Is it because they want to cut a deal, but he's not listening to it? Like I said, I don't get it. I think they've taken a completely wrong approach to this particular matter, and I think that it's not going to end well. Hopefully we'll find out here in just a little bit, because this case needs to progress. I'm a little surprised that the court needed another break to prepare the finding of facts and conclusions of law. Kind of like, hey, Judge, all the attorneys probably worked late last night outlining their stuff. Why couldn't you have done that? Was there something that was so unique that was presented that now you have to somehow clarify that? I don't know. Alicia, Scott, why do you think murder charges haven't been brought yet as it relates to Lori and Chad? Well, I've explained this before, because I think they have proof issues as to who actually killed the children. Alex Cox, the sister of Lori Vallow, is now deceased. I think a reasonable argument could be said that perhaps he's the one that did that. And unless you can prove and show that they were involved with and know that something bad was going to happen to the children, what evidence do you have? Obviously, Alex Cox is dead. Even if there's things on the phone, you have evidentiary issues that may not be able to, get over those hurdles. Just because you have a hunch or a suspicion doesn't mean that it is legal and competent evidence to overcome those evidentiary hurdles. And understand, it's supposed to be tough when you go to court, whether it's for the prosecutor or, if you have a civil case, it's supposed to be tough to prove a case because you just don't want people saying they did something wrong to me. Okay, what? When? Where did it happen? Do you have any witnesses? You have to be able to prove those things. I think that and I've said this before, Mr. Woods seems like a competent prosecutor. If he had enough evidence to charge it, I think he would. The police, obviously they were able to discover the bodies in this particular case of JJ and Ty Lee. And if they thought that they had sufficient evidence that they could present to a judge a warrant for the arrest for murder, I'm sure they would do it. The bottom line is there's something missing in their evidentiary link for Lori Vallow and Chad Daybell. And like I said, it's supposed to be tough. Burden of proof is proof beyond a reasonable doubt. The standard to get a warrant is simply probable cause, a much lower standard. So I think that if they had it, they would do it. I don't think they have it unless and until one of the co-defendants in this particular case would decide to cut a deal and point fingers at another person. But not a whole lot of incentive on their part to do that, because then basically they would be in trouble, so to speak, and probably not get a deal. I mean, look at it. They're facing 10 years, 10 years on 2 counts of basically concealing evidence, right? You get charged with murder, you roll. But what's the incentive? Hey, worst case scenario, I'm looking at 10 years. Okay. Versus life or possibly even death. Not sure it would be necessarily a death penalty case, but the bottom line is, what's the incentive? Unless the incentive is a golden ticket to go home, I just don't see it. So, as I Am Human here states, the pings, the closed circuit TV, there's 26,000 pages of electrical data evidence to sift through. Yeah, but you know what? They've had 8 months by now to do that. Like I said, I think they would have done it by now. Hey, I've been wrong. I can be wrong. I'm going based upon what I know, and I will change my mind based upon, whether the law changes or whether the facts change. But based upon the facts that I know right now, that's why I think basically nothing is going to happen, so to speak. So that's where we remain on that. What time did the judge head out? Do you remember, Frank? The heart.
There should be online again in 15 minutes. Around 15 minutes.
Oh, about 15 minutes?
Yeah,
Okay.
in about 15 minutes.
Salt of the earth. Scott, would you do what Smith did if your client didn't complain? I would, Garrett Smith was the attorney for Ms. Shiflett who turned over this recording. More than likely, I don't know, I don't recall off the top of my head whether he reached out to Means or if Means and Pryor reached out to him and said, oh, I got this thing. They listened to it. It's inappropriate because Mr. Means, got his feelings hurt that he said he wasn't competent. And that's affecting, his ability. I mean, listen, no one's refuted the fact that Mr. Wood said that Mr. Means has never had a felony case before. Okay? Just because you're an attorney doesn't necessarily mean that you are competent in a particular area of law. You can get up to competency, but it doesn't necessarily mean that you are competent just because you're an attorney to handle every type of case that comes through the front door. We'll see. I mean, I think it's ironic that the defense was so concerned about pretrial publicity, his clients receiving a fair trial, and they're the ones that have attempted to perpetrate a further growing circus in this particular case. Like I said, we'll find out together. You know, it's kind of like when I tell a client we're waiting for a jury verdict, and you tell him, all right, this is the second worst part. And he says, you know, the client will ask, well, what's the worst part? When they say they have a verdict, okay, it's your stomach just sinks, you know, you come down. It's like, you know, we'll find out together what happens. We're going to find out at the same time what happens. I think if I was the judge, based upon what I've seen, and I've watched the closing arguments and watched just about every minute of the previous hearing, I think if I were the judge, I would find that the defense hasn't met their burden, that none of this rises to the level of what they would do. And I think I would admonish both of the attorneys for their choice of words going after Mr. Wood the way they did. You can say lots of things. You can say, Judge, I'm concerned. You know, concern is, Judge, I'm concerned the way things were conducted. You can say, I don't like the way things took place and went down, without accusing somebody of criminal conduct. It's just going to be, I think it's going to be interesting. Like I said, I think Mr. Woods will remain. If he does remain, it'll be very interesting how things are conducted here on out. But think about it. If the prosecutor that's prosecuting your case, the one that can give some leniency, so to speak, if there were going to be a plea bargain in place, do you think after being wrung through the mud, called all kinds of disparaging things like you're a liar, you are unethical, you manipulate coerced witnesses, do you think you're going to do any favors above what you are professionally and legally obligated to do? I just think it's, like I said, we'll see what Judge Boyce says he's going to do here shortly. But the bottom line is we'll find out together. You know, generally overall, and I've said this before, I think Mr. Pryor obviously is a very experienced criminal defense attorney. As another defense attorney, you can tell that he is. He kind of gets to the point, maybe a little verbose, a little talk, you know, over the top, but means, and maybe it's just me, he probably would say the same thing about me, but man, that CottReisch just bugs the hell out of me, every word that comes out of his mouth. But there's something about Mr. Means, and I'm telling you straight up, I'm not going to, every time he opens his mouth, I literally just want him to sit down. The less he says, the better. Even when he's sitting there scribbling, always looking down at his paper when he's doing, there's something about him that just rubs me the wrong way, and I don't know what it is, but I'm telling you that in complete candor. Just because, you know, I don't know, it's just my personal, there's something about the way he conducts himself that he just bugs me. I don't know why. Yeah, you know, I am human. Pryor throws word salads everywhere. Yeah, he may not have been as focused as, say, perhaps Mr. Evans, but you know, that's the defense attorney in him. Sometimes you got to deal with what you got. But I just simply, okay, Marion's probably saying why everything's dehydrated. You're probably right. I have Been drinking too many Red Bulls lately. Not enough water. Then I get these lines where my head's going to explode. Can you go read this, Scott? I don't have control of that comments. Do I have to go to... Go back up. Yeah, go up a little bit higher. I can't remember where. Okay, go down a little bit, please, in the comments there. Sorry, I'm just trying to look at the comments. I don't have control of that here. The hardest working man in show business, Frank does. And let's see here. Question, Scott Woods. Sorry. Okay, Scott Woods was recorded telling Summer her sister will be charged with conspiracy to commit murder. Was he lying to her since no charges have been filed to date? Wow. No, wasn't a lie. At that time, the way I read it was, we could or we're going to charge her with murder. Is that a secret? Is that something, it's not like he's talking directly to her. Does he know that that she's gonna talk to him? I don't know, maybe not, but hopefully they're not going to be talking about the case on the phone, because it'll all be, copied, I'm sure. But, the bottom line is, he's saying, hey, we're going to charge him with conspiracy to murder. Now, this was back in October. I think that was the date of the interview. I don't have it in front of me, but it sounds about right. But the reality of it is that is, that's what he said he was going to do. Okay, he hasn't. Because an attorney, a prosecutor, has an ethical obligation that can only bring charges if they believe they can prove it beyond a reasonable doubt. And if he thought that he had that to do that, that's okay. But they can't do it until they has that ethical obligation to do so. But saying, hey, I'm going to, that's his goal. It's the prosecutor saying, hey, as a family member, I understand you're in a hard spot. You want to help your sister, but you also want to make sure that justice is there for Tylee and JJ. I understand that. Prosecutor saying, I can bring the most serious charges I can possibly come up with. Once again, that's my opinion. I don't think that was anything inappropriate whatsoever. We touched on it yesterday on our show, where we talked about the fact that the defense didn't want any more briefings, but yet it seems like at least Mr. Means submitted a brief. The prosecutor submitted a brief, kind of a summary of their closing argument, which is fine. Most judges usually like that, but the defense didn't want it to be required because it takes time, and time equals money. Attorneys like to be working on a particular case. They like to work throughout their day, most of the day, so that they can make money. And if they're not, working on a case that they can't get paid, I brought it up that when they start complaining about the cost of, going to court, writing briefs, showing up for court, it costs money. That usually means the funds are drying up. This case, given the amount of discovery that would be there, all the data from the phones and all the dumps and everything like that we heard about back at the preliminary hearing, that'd be a full-time job. And then you go and start create, little rabbit holes. This is why, and people don't understand it. An attorney says, hey, I'm not going to charge you a flat fee. I'm going to charge you an hourly fee. Because in a felony case, you do not know what rabbit holes that you may have to go down and investigate. And they have to be investigated and they have to be brought up. Well, why didn't you do this? But then when the attorney starts saying, hey, we got this issue here, you're in for a penny, you're in for a pound. What are you going to do? Work for free? Well, you're not going to do that more than likely until all the money's gone. And then they're going to have to decide, do they want to be working on the biggest case in Idaho ever for free, or do they want to get paid for it? Do they think their 20 minutes of fame will be enough to carry them for the next 20 years if they work for free? No, Probably not. What was the attorney's? He represented. Why can't I think of his name? The attorney for Mark O'Mara. That was it. Mark O'Mara. He represented George Zimmerman. He got on that case. Zimmerman didn't have any money. He kind of stayed on. I've talked to Mark O'Mara at National Trial Lawyers. I think he's the president of National Trial Lawyers, or he was. Maybe he's moved on from that. But he and I are, he does criminal work. But when you talk to him about the George Zimmerman case, it was the kind of case where he got on and it's kind of in for a penny, in for a pound, and they had to basically set up a defense fund for that. And they won the case. It worked out well for O'Mara. I think he got a gig with CNN to be their legal contributor at some point. I don't know if he still does that. And he's done well for himself. I think now he does a lot of some mass tort stuff, but things are going well for Mark O'Mara, and I wish him very, very well. But when he was on that case, he was literally like, they're going to repossess the car. How are we going to make the bills? Because there was no money coming in because the case was a full-time case, and that's what this case is. And you think about it. Let's just say they're making $300 an hour, $400, $200. You round the numbers off wherever. Assuming they're working, let's say 8 hours a day. If they come in and they work on nothing but that, billing 8 hours a day. Some days it's going to be more, a little less. But figure, even at $300, that's $2,400 a day. How quickly does that go by? You do that a couple days in a row. That's $5,000. That's 10. It's like $1,250 a week. If you're working on it full time and reviewing all that discovery, that's how these cases can get so expensive so quickly. And when you have big cases like this, and God forbid you have more than one attorney working on it, so that you keep some perspective and say, you have to do that. We're fortunate enough here in our practice where we have 4 other attorneys here that work for me. And it's great because you can bounce things off. Hey, will you take a look at this? Will you read this motion? Am I going on a limb here? And there's been times where I got all fired up and somebody in my office will say, let's pump the brakes on that, Scott. Let's take a look at this. And I'm glad they did. And there's other times where it's like, is that an issue? And other people are like, oh, that's a huge issue. So it's just good to have that. But, these cases are expensive, and most people cannot simply afford to defend a criminal case oftentimes the way that they are intended or should be represented. I mean, it takes time to go to the jail, talk to the clients, go over things, explain things to them, how this fits into the bigger picture. It takes time. I mean, I was at the jail last night till 7:30, going over information, explaining things, make sure everybody understands it. These are reasons, these are tactical decisions that we're making. We're going to push it on, explaining things. That takes time, let alone going back and reviewing and figuring out, all right, how does all this stuff fit into the case as a whole? How does this fit into the overall theory? What is the defense? What evidence do we have to come up with to fit this particular defense? Do they have enough to make their case under the elements? Is there some case law out there that I need to research that's interpreted the instructions a little differently? So it just really depends. And I'm telling you, it's expensive. I mean, people just do not appreciate that. But most serious felony cases, we take on an hourly fee basis just because you do not know what issues are going to pop up. Next thing you know, you spend 2 days on a hearing that you didn't think was going to be anticipated. Okay, I'm being told by Frank that we are coming back on. We'll see what the court concludes, and then we will provide, I guess, our analysis, and we can see whether I have to eat some humble pie, or I can say, I was right. I guess we'll wait and see. As I tell my clients when we wait for that jury verdict, we'll find out together. So looks like we're going to go back. So I guess we'll go. I guess I'll continue to talk until they actually come back on here as well. Good question. Tammy, could the judge come back for sanctions against the defense attorneys? The biggest sanction in this particular point would be to deny their motion. They just spent all this time on this motion, and if they lose it, that's going to be a big blow to them. They burned bridges with the prosecutor. They spent a bunch of their clients' money and got nothing out of it. That'll be a pretty big sanction. The judge is not going to be like a civil case where they're going to say, this is frivolous, and we're going to impose costs against the defense. So not really. Now, the prosecutor, Mr. Evans, did state that the appropriate forum, if they think that something unethical has taken place, is with the bar. That's true. The court has no real ability to sanction what they refer to if it was unethical. Obviously, the big sanction here would be if they thought it rose to the level to remove Mr. Wood. That would be a huge sanction, and then there'd be an issue with the bar. But that's it. But normally, you don't grieve another attorney in the middle of a case, because that's when emotions are high, and it's just not done. I mean, it's sometimes called good lawyering, but these days, it just seems like everybody is everything has to be a gotcha. Everything has to be a gotcha, and I just don't get it. And everybody wants to get the other side in trouble and do this, and I just do not. I don't get it. Will Mr. Wood, if he's retained, or not retained, but not removed from this particular case, what will they probably do? I assure you, he's going to have a witness there if he's having any introductory comments at all. And that's a shame, because, a good prosecutor would tell you, I don't have to turn over everything that we talk with about, the family. Hey, this is what we think we're going to do. This is what we're asking for. Is there something that you could live with? Because the trial process is long, it's lengthy. Is there something that you would be willing to accept if we, were to resolve the case? And we've talked about this before. These are the conversations that prosecutors have with family members. Okay, hey, this other attorney on the other side, he could be really good. Say, hey, I've dealt with him before. I think I've got enough evidence to prove the case, but if there's some guy that could possibly pull this case out, it could be that guy. Okay, you just never know. But that's what prosecutors do when they're talking to family members. Like I said, we will find out here, hopefully in just a few minutes, what the court decides. I think that, let's see, Janine Scott, thanks for this. The time when there's so much distrust of our legal system, you bring us the facts. Well, I try to. I mean, and we've talked about this before. I don't want to repeat myself, but, some people get so upset when I give analysis of a case where, for example, the Ahmed Arbery case. I've read the jury instructions, the law as it relates to that particular case, and I said I think all those people are in trouble, and they're probably going to go to prison. I don't think what they did was appropriate under the law, and their defenses that they were claiming are not there as well. And then people get mad at me, and then they say, well, how can you think that that Kyle Rittenhouse kid has a defense up there? Well, because I've looked at, I'm not going to say it's all of it, but some videos that show that there were a lot of things going on that weren't known at first. And people get upset with me like, well, I don't know. I just don't understand it. But as an attorney, you have to look at this and analyze this. Okay, I want to help my client, but do we have what it takes to prevail? You have to have those conversations saying, this is good for one side, this is good for the other side, whatever side you're on. But you have to do that analysis. And if you just ignore it and say, I'm right, guess what? Your client could be going to jail and you're not doing your job as an attorney. And, it's one of the things that they teach you in law school is to think like a lawyer, think like an attorney. It drives some people nuts, and sometimes you maybe overanalyze things. But the reality of it is, it's a good way to think. It's called, what proof do you have? Just because somebody says it's true doesn't necessarily make it that way. You have to have facts, evidence, eyewitnesses to something to do that. And not just, hunch, suspicion, speculation, bottom line. And, yes, are there things that we know in life with absolute certainty? Not necessarily. So you're not going to have, absolute proof, but you have to have proof. You have to have some evidence for that. And, the standard in criminal case is reasonable doubt. It's not a vague, imaginary, or speculative doubt, but a doubt that would cause people to pause in matters of great importance and say, am I convinced beyond a reasonable doubt? Not all doubt, not a shadow of a doubt, beyond a reasonable doubt. Would a reasonable person do that? People have doubts all the time that they overcome. Think about when you buy your first house. You think, man, I got this house. I'm spending all my money. And it keeps you up at night. Did I do this? Is this the right decision? You have doubts about it. But you work through it and say, yeah, it's a good investment. We're going to have a family. It's going to appreciate in value. It's really scary, but it's going to be okay. You've overcome that doubt. Reasonable doubt. Okay. So and I think that's the thing. Like I said, if you start thinking like a lawyer, sometimes it's a little frustrating to the loved ones around you. You can even come across as a little insensitive. But the reality of it is, it makes you think and say, okay, that's fine. Trust, but verify. But, you get very cynical in this job, particularly when you start getting burned a few many times, whether it be a client or anybody else. It's trust, but verify. I like you. You seem like a good guy, but the reality of it is, bring me proof. Client says, "Oh, I wasn't able to, I wasn't able to make a court today. I was in the hospital." Okay, that's great. That's great. All you need to do is, get me something from your doctor to say you were there. Not that I don't trust you, but no one else does. So those are the kinds of things that you have to do as an attorney. You have to be very skeptical sometimes, and it's frustrating. But the reality of it is that you get burned enough by people that you thought you can trust, and then you don't. And like I said, it's frustrating. But that's thinking like a lawyer. So let's see here. Let's see here. Man, you'd think they would come back up by now, don't you? We haven't lost anything, have we? Man.
You should use it.
Yeah. Okay, so let's talk. Like I said, I think the judge will rule the way I think the analysis will go. But let's say he doesn't. What does that mean if there's a special prosecutor on the case? Well, they'd have to appoint a special prosecutor. That prosecutor would have to get up to speed, which would mean to go over all the pleadings, paperwork, all the discovery, everything in the case. And guess what? Mr. Wood would not be able to help them really do that. They're off the case. You can help with a smooth transition, but he can't consult. So yeah, it's which would take time, and it's not going to result in a continuance of the speedy trial in any way, because it's not the defense asking for it. The prosecutor would just have to get up to work. Hopefully, if that were to take place, Mr. Woods would have the Emma, are you coming back after, not the verdict, it's a ruling by the court as to whether there'd be disqualifications. But yes, we'll stay on and talk about the ruling. I don't understand why it's taking so long. It's a little puzzling to me, other than he wants to make sure he gets it right. And I get that, to make sure he's dotted all his I's, crossed all his T's, so that it would stand up on any kind of appeal if there was one. But you would have thought that he would have written that out pretty much last night, and we'll see. I don't know. Surprised. But yeah, after the judge does give his opinion, then the plan is at least to talk briefly about the analysis of that, and we'll go from there. Probably won't put up our regularly scheduled show today, just because this has gone on so long. So we've interrupted our regularly scheduled programming to bring you this live special event. But I appreciate that everybody has stayed on even through the break. Hopefully I provided a little more entertainment than looking at a blank screen that says the seal of the great state of Idaho as we wait for this. Hopefully provide some information regarding how this may come out. I'm trying to look at some of the comments here. Linda, did the defense attorney threaten to spend more unknown sums of dollars in retaliation of Wood's conduct? Weren't those attorneys complaining about how much money it was costing? I didn't take it as they were threatening to spend more money, just that it would take more money because now they have to send investigators out to go talk to all of these particular witnesses. Well, I would hope that they were going to do that anyway. So I'm not exactly sure what that would entail. On a big felony case, when you have lots and lots of witnesses, this is the type of situation where you would have to hire an investigator. So when we talk about all those expenses for the attorney, and the attorney may go out with the investigator, maybe not for all of them, but the investigator has reviewed the discovery, so he can ask intelligent questions. Some attorneys say, hey, I trust you, Mr. Investigator. Let's talk about the discovery. This is generally what I want to go over. Go talk to him. Some attorneys write out specifically every single question. Don't deviate, don't ask of that. But guess what? Private investigators don't work for free. If they have to travel, they like to get reimbursed for their airline tickets. They like to get reimbursed for their mileage, their meals, all that stuff. The client pays for it. So whatever amount of money that was paid to these attorneys, I can imagine it's going through real soon. All right, Judge Boyce has returned. We'll go back to the ruling. We'll see, did I nail it or do I get to eat my words? We'll talk to you afterwards.
Are you able to hear on your right there?
Right, Madam Clerk, are we ready?
Yes, Your Honor.
All right. Appreciate your patience. We're starting a little later than I indicated. We'll be back on the record. These are cases CR 22-2755 and CR 22-2838, State versus Chad Daybell and State versus Lori Vallow. The court took a recess after considering the closing arguments today, and I'm prepared to make a ruling on these motions. In this case, the defendants have each filed motions to disqualify the prosecuting attorney. The court has considered the pleadings, the evidence submitted in the hearing on January 6th, and the arguments that were submitted today. As a preliminary question, the court has to determine what is the appropriate standard of review for granting or denying these motions. Pardon me. As has been pointed out by both the experts and in argument, there really are no Idaho cases directly on point to identify what is the precise standard for this motion to disqualify a prosecutor pre-trial. And there's no Idaho precedent the court's aware of where this remedy has been ordered by a trial court in a pending case. Neither defendant provided any citation for an appropriate standard of review, but made argument in support of their belief of what the standard should be. The state has referred the court to a standard in the Weaver versus Millard case, which was set forth in the state's brief. That case is a civil case, and while it's instructive to the court, I do share a concern that was raised by Mr. Means in his rebuttal argument that the civil standard may not be appropriate for a criminal case, and that would be because of the heightened duties that a prosecutor is charged with and the additional constitutional protections that are afforded to criminal defendants versus a civil standard. And so in the court's opinion that the Weaver versus Millard may not be the correct standard and will not be used for determining these motions at this hearing. There is some Idaho case law out there that for good cause, a trial court can in its discretion appoint a substitute attorney for an indigent defendant, for example, and that would be State versus Lippert, 145 Idaho 586. However, that is for the constitutionally guaranteed right of representation of an indigent defendant and does not necessarily apply to a trial court having the ability to order a substitute attorney to represent the state. In looking at other jurisdictions then, the court has located a precedent out of New York that is persuasive and will be adopted in this case, as I think this is a novel issue in terms of precedent. The case I'm referring to is called State versus Paperno, a 1981 case out of New York found at 54 New York 2nd 294. And that case deals directly with the issue of a defendant's pretrial motion to disqualify a prosecutor. The standard as stated in that case is as follows. It indicates first, the burden is on, well, let me read that directly from the case. The standard they use is that on a pretrial motion to disqualify the prosecutor, it is incumbent upon the defendant to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. A mere assertion by the defendant that he intends to question some aspect of the prosecutor's conduct is insufficient. Rather, the defendant must demonstrate that there is a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So according to that, the burden is on the defendants to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. And second, there must be a showing that there's a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So in reviewing then the motions with that standard, I look at the motions which mirror each other in their allegations. The allegations are, number one, that the prosecutor alleged misconduct violated due process rights of the defendants. Under the Idaho and U.S. Constitution, right to a fair and impartial trial, that the prosecutor engaged in coercive, unduly influential, and intimidating tactics to manipulate a material witness in this case. The second allegation in the motions is the prosecutor in this case violated the Idaho rules of professional conduct, as well as the ABA rules by his actions. The third allegation is the prosecutor's alleged misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. Number 4, the allegation that the prosecutor's alleged misconduct has made him a material witness in this criminal case. And number 5, the prosecutor's alleged misconduct has caused the potential for future civil litigation directed at Fremont and Madison counties, as well as the prosecutor. And then number 6, that the prosecutor's alleged misconduct has included concealing evidence in violation of Brady and Rule 16 of the Idaho Rules of Criminal Procedure. The court would note that in terms of the fourth allegation about the prosecutor being made a material witness in the case, there is some Idaho precedent on authority on when that occurs, and that would be the State versus Aguilar case. And that case is at 135 Idaho 894, and that states that the party seeking such testimony, meaning from a prosecutor, must demonstrate that the evidence is vital to his case and that his inability to present the same or similar facts from another source creates a compelling need for the testimony. Also, that a defendant has an obligation to exhaust other available sources of evidence before a court should sustain efforts to call a participating prosecutor as a witness, and that case states that such motions are generally disfavored. In determining then these allegations in the standard I've announced, then I've considered the evidence submitted, including the submitted pleadings and exhibit and the testimony of the 3 witnesses, including Garrett Smith, the attorney from Arizona, the expert witness opinions and testimony and reports of Dr. James Davidson and Dr. Samuel Newton. I've also considered, of course, the transcript of the audio recording, as well as listened to the recording of the potential witness in this case and her discussion she had with Mr. Wood, which was submitted in the evidence of this hearing. So getting down to these allegations, counsel's alleged that there may have been or was a violation of Idaho Code 18-2604, which is Idaho's witness tampering criminal statute. Of course, to make a showing or to sustain the burden of violation of that would require the highest burden of proof because it's a criminal statute, so that would have to be shown beyond a reasonable doubt. Regarding the allegations of the Idaho Rules of Professional Conduct, of which there have been many allegations made, including rules 3.3, 3.4, 3.7, 4.2, and 8.4 of the Rules of Professional Conduct. The court considers, as a fact finder in this proceeding, that the standard of review to determine if there's been any violation of the Idaho Rules of Professional Conduct would be clear and convincing evidence, and that would be found under Warner versus Stewart, 129 Idaho 588, and the matter of Daw, 128 Idaho 80. In regards to those alleged violations of the Rules of Professional Conduct, the Idaho State Bar governs the licensing of attorneys in the state and also enforces the Rules of Professional Conduct. There's an Office of Bar Counsel that conducts those hearings, which are administrative hearings. The Bar Counsel has the responsibility of investigating, and I'll quote from a rule, all matters involving possible misconduct called to their attention, and that's Idaho Bar Commission Rule 504B2. The state, in its brief, pardon me, I think I misplaced that, cites to the case of Cosman versus Dinius, which is 165 Idaho 375, which states unequivocally that the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar. So in other words, there's a separate governing agency that would make a determination as to whether or not any sanction should be imposed for violation of the Idaho Rules of Professional Conduct. Now, I understand that as the sitting and presiding court in this case, if I were convinced that an acting prosecutor was engaged in conduct that would result in a fair trial, then I would have an inherent ability to grant this motion, even though as I have mentioned, I don't see any prior precedent, or I haven't ever heard of that happening. The Idaho Constitution under Article 5, Section 2 does grant the court with the inherent right to administer justice in a case. But again, the standard I'm looking at for the motion would be the standard out of the State versus Paperno, New York case, which is that the question of, one, did the pretrial activity of Mr. Wood in this case render his participation in the trial unfair? And two, was there a significant possibility that this pretrial activity will be a material issue in the case? In this case, then, we're dealing with the comments that were made to a potential material witness who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. The prosecutor, based on these allegations, could of course choose to recuse himself, but there's been no indication that he is doing that. Mr. Woods could, as if the allegations were true, be charged under that statute of Idaho Code 182604. There's no evidence or indication that that has happened. There could be a sanction issued by the Idaho State Bar, and their sanctions may include a private reprimand, a public reprimand, a suspension of license, or disbarment. Those are possibilities out there. There is no evidence before the court that the bar has taken any such action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied. Now, if Ms. Shiflett in the future is called to testify at trial in this case, the court would require a pretrial hearing based on the evidence I heard at this hearing, which has been referred to as a taint hearing, and that was done in the case of State versus Severson, 147 Idaho 694. It's discussed in Head Note 46. So I would require that type of hearing before her testimony based on the evidence been presented by the defendants in this case. The court at this time has no other information of any other such conversations that may have occurred with other potential witnesses. If they did occur, then there may be a possibility of a future request for additional taint hearings for those witnesses as well. But that's not an issue before the court, as the only information submitted was the transcript and recording of the conversation with Ms. Shiflett. So finally, there were some concerning things in the recording in regards to the derogatory comments made by Mr. Wood about Mr. Means. I'm not going to issue an order to apologize or anything to that effect, but it's certainly my practice to always encourage a civility amongst counsel in my cases, and I'll just leave it up to Mr. Wood to determine whether or not he thinks that is an appropriate thing to do in order for continued civility and professionalism going forward in this case. Finally, of course, if the Idaho State Bar were to take any action, this court would be advised of that by the State Bar Association, and this issue may be subject to being reopened for further findings and conclusions if I received any such information. But any decision regarding a sanction for any violation of the ethical rules, if they did occur, is left to the sound determination and discretion of the Idaho State Bar. So that will be the court's ruling on these motions. Mr. Evans, I would ask that you prepare an order indicating that the motions are denied, and also include in the order the indication that the court would require a pretrial hearing to have an in-camera interview of Ms. Shiflett before trial, or well, don't necessarily say it would be an in-camera interview, just say that a hearing, pretrial hearing would be required if she is in fact to testify at trial.
Very good, Your Honor. Thank you.
All right. Mr. Pryor, do you have any questions on the court's ruling?
No, Judge.
Thank you. Mr. Means, any questions on my ruling today?
No, Your Honor. Thank you for your efforts.
Thank you. And Mr. Evans, does the state have any questions on my ruling?
No, Your Honor. Thank you.
All right. Counsel, we do have some other hearings we need to get scheduled, including, I guess, hearing on a motion to compel, change venue, and motions to dismiss. My preference, given the time, and I'd like to just arrange a conference call with counsel to look at calendaring and get these matters set. So I'll be available in the coming week. I'll reach out to counsel and let's look at our calendars and see when we want to get these additional motions scheduled. All right. Anything else we need to bring up on the case this afternoon then?
No, Your Honor. Thank you.
No, Your Honor.
All right. Thanks, everyone. And thank you to the Idaho Supreme Court for their support, as well as Fremont County. We'll be in recess.
Well, there you have it, Crime Talk aficionados. Fortunately, I don't have to come here and eat some humble pie. As the court agreed with my analysis, that nothing rose to the level which would result in any kind of sanction that would require Mr. Wood to get off the case whatsoever. I'm surprised the court had to take such a lengthy recess to issue that order, because you would have thought that he would have had that prepared already. Basically, his analysis was that of mine, that the defense who brought this motion, who had the burden for this motion, had to present some evidence that was somehow going to show that the conduct somehow tainted the fairness of the trial or that of the witness in any particular way, and basically adopted the arguments of the prosecution in his ruling. I thought it was a little funny in regards to the referring to Mr. Means as not as a competent attorney. He basically said that as professional attorneys, we should all have civility, and he expects ongoing civility among professionals, and basically you shouldn't disparage them. And I totally agree with that, but it's not like he's going to have Mr. Wood apologize to Mr. Means. But he did say basically, hey, if you can't be civil, guess what? Bring it to my attention, and we'll take care of it. It was interesting that the Bar Association, Idaho Bar Attorney Regulation, was involved because the judge referenced them, and there may already be a companion case whatsoever with the attorney regulation as regards to Wood. I would not surprise me if that's what took place, given the way these proceedings went forward, but I think that they would reach the same conclusion whatsoever. At most, maybe a public censure, but I don't think that there's, and like I said, I'm a defense attorney, and you know, if I thought the prosecution was doing something wrong, I would jump all over it, and I just didn't see it here. And once again, you know, you have a situation where the defense, predominantly Mr. Means, remember he brought the whole, my client needs a bond because they're listening to telephone calls at the jail. Well, turns out that wasn't the case. They put up the sheriff and they said, hey, maybe we record one, but we deleted it as soon as we realized it was an attorney call. Waste of a day, waste of client's money. Here, who knows how many hundreds of hours went into preparing for this. And you really had to ask yourself, what was it going to accomplish? I didn't see it. Now all you got is a prosecutor who is not going to trust you, is not going to give you any benefit of the doubt and say, hey, that prior guy, that means guy, yeah, I don't understand. They're just doing their job. Good guys. At the end of the day, at the end of this case, we'll all shake hands and go have a beer or something. Don't see that coming forward. I've generally looked at it in life as you think I've done something wrong, fine, you keep me in the courts. But as soon as you grieve me, you start saying unethical things about me, game on. Because at that point, you're messing with my livelihood. And here in this particular situation, Means and Pryor, we're messing with Mr. Woods' livelihood, his ability to practice law by basically making allegations that he had engaged in criminal conduct where his law license could be suspended. I wouldn't just brush that off. I would remember that for a long, long time. That would be a little hard to get by, to say the least. And at the end of the day, what did they accomplish? They pissed off a DA, made them look like they were, for lack of better terms, I don't know. I just don't get it. One of the things you learn as being a defense attorney is if it's a trial case, you save what you have for trial. Clients always want to file motions. File this motion, blah, 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 file the motion. Okay, but I'm telling you, it's probably going to be denied. The case law is not in our favor, and the judge is going to follow the law. And that's where it's going to come out. And I hate to have to tell the client that that's probably what's going to happen. We'll file the motions, but don't expect to win it. If you're going to win it, you're going to win it at trial. I have literally lost every motion. I have a judge, I swear to God, I don't think he's ever granted a motion in my favor, but I've gone to trial and won like 3 cases back to back to back in his courtroom. And it wasn't for the prosecutor or his effort not to do that. So, to make sure that wasn't going to happen. But that's just a part of life. You don't always get to run to the teacher and say, somebody's picking on me. They're being mean to me. We wanted to know about this 18 minutes, and what if it wasn't recorded? Okay, well, it was. And what's wrong? So I just do not see it. I told you that when the whole issue broke out. People were sending me things saying all these people from Court TV were saying this was serious, it was egregious. Okay, and I don't watch Court TV, all that other stuff. But I wonder, when was the last time these people practiced law? When did the last time they ever have to deal with prosecutors on a daily basis? You don't go putting fingers in people's eye and poking them in the eye and then expect them to be nice to you. Don't get me wrong. There's an opportunity where you have to be mean, and sometimes you have to poke some people in the eye, figuratively speaking, obviously. But you don't do it unless and until either A, they bring it on, or you've tried everything else. You've tried being nice. You've tried to be completely hospitable, and they just keep treating you like crap. And I've had situations where I've told DAs, like, is there something I've done to you? Because I don't think we've ever met, and you just treated me real rude. And I had a young DA once, tell me, well, I just don't like your client. Like, okay, but doesn't mean you have to be disrespectful to me. In fact, I may not like your boss, but let's do this job. You're doing your job. I'm going to do mine. We're going to both do it to the best of our abilities, legally and ethically. So there you go. We'll see. There may be some dueling grievances going on in this particular case. If Woods and Pryor, if Means and Pryor grieves Mr. Wood, guess what? There may be a counter grievance going on. And like I said, you're not supposed to go around making those accusations unless you can absolutely back it up. You just don't do it. So anyway, I think that's all we've got for today. It's been a long day. Thanks for everyone sticking it out. I think what we're going to try to do is cut out kind of my commentary and put it up again, so hopefully everybody can see it. Maybe we'll put the judge's ruling in there so you don't have to watch the whole, how many hours was it? 2+ hours or something? 4 hours with a little bit of waiting. We'll put, hopefully the interesting part, me and the ruling into a condensed video and put that up. So relieved. I was getting worried that maybe I was going to have to eat that humble pie. That's okay. I could do that, but I didn't think I was going to be wrong. We try to get it right. We try to get it right for you because why? We want Crime Talk to be the place where people go when they want and need good advice based upon the information we have. So thank you all for watching. Thanks for watching Crime Talk. We'll try to get that video up for everybody to watch again. Thanks for sticking it out. Absolutely appreciate it. Have a wonderful day, and we'll see you next time on Crime Talk.